Go ahead and mute it.
I hope they did.
Check, check, check. Good morning, Commissioner Aguilar. How are you?
Good morning.
How are you been?
Good.
Good.
Thank you.
Yeah, we haven't talked in a long time. I just wanted to say hello and good morning today.
Oh, yes, thank you. We had some rain recently, so everything is good.
Yes, rain makes everything better. We got like an inch and 80. What is today? Monday night. And it's still muddy.
Yeah.
It's wonderful.
Yeah.
Here in Santa Fe.
Well, we're on my way.
Oh, yeah. So John's saying a half inch here locally. So
That was Tuesday.
on Tuesday. That was yesterday. Yeah, rain. It just smells better after a good rain, and everything just seems fresh and wonderful. Kind of like 4 foot of snow in December. It's just lovely. Anyway, good to hear your voice, Commissioner Vicente Aguilar.
Thank you, and looking forward to the meeting.
Good morning. How is everybody?
Good morning, Madam Chair.
Mr. Vice Chair, how are you?
Doing fine, Madam Chair.
Great.
Is Mr. Smith on, or is that just his phone?
No, that's me.
Good morning, Mike. I hope you're doing well. Hope you had a good week.
You as well.
Thank you, sir.
Well, I've got 9:30.
Man,
Yes, sir. And I see our Vice Chair just dashed away.
yeah, dodging a meeting again, I tell you.
Oh, boy. Guy's so flaky. I think we'll get started. Good morning, everybody. This is the regular open meeting of the New Mexico Public Regulation Commission. It's Wednesday, August 10th at 9:30 a.m. I'm Chair Cynthia Hall, and we will call ourselves to order and have the roll call, please. Michael, can you call the roll?
Sure. Commissioner Byrd,
I'm a present.
Commissioner Fishman, Commissioner Hall,
Present.
Commissioner Maestas,
I'm here.
and Commissioner Vicente Aguilar.
Here.
Going back, Commissioner Fishman, are you present? Appears we have 4 commissioners present. That constitutes a quorum.
Thank you, Mike. Okay, we'll move on to the Pledge of Allegiance. Let's see. Judy, could you please honor us with the pledge?
Yes, can you hear me?
Yes.
Okay. I pledge allegiance
Allegiance
to the flag
of the
of the
United
United
States
States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico,
and the Zia
the
symbol.
symbol of perfect friendship among united cultures.
Thank you, Judy. Now we have consideration and approval of the agenda. Are there any changes to the agenda?
Madam Chair.
Yes.
I believe Mr. Fisk wanted one of, I don't know which one he wanted off,
Yes.
but he had sent an email,
Yes, I
Yes,
can
he wants
check here. It's
258.
matter number 21-00258, which is the first item on the regular agenda, I believe. Let me see here.
yes, it is. It's item number B6. And you would like that removed from the agenda, is that right, Russell?
Yes, Madam Chair, and I'll place it on for next week.
Okay, fine. Thank you very much.
And Madam Chair, I will move the agenda as
Oh,
amended.
1 second, I
Sorry.
have a
Go
change
ahead.
as well. Well, Hans, you can announce it if you want.
Yeah, thank you. Two other slight corrections. The minutes that are being approved today are actually the July 21st open meeting.
Yes.
We met on Thursday that week, so inadvertently had the Wednesday date of July 20th. But the meetings in question are actually at the July 21st open meeting. And Commissioner, I believe you wanted to remove the review of the work plan under discussion with commissioners.
I do. We received material from people, but it's still not quite in the form I wanted to see, so we'll bring it back next week. So those are the changes. Let's see, and I believe we had a motion. Do you
I'll
want to
second.
consider?
I'll
Okay.
second the motion.
Any discussion on this? No? All right, we have a motion and a second. Let's take a roll call, Judy. Or Michael.
No problem. Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Byrd.
Aye.
I'm going to try Commissioner Fishman. I can't see if he's on or not. Commissioner Fishman? Does not appear he is on still. Commissioner Hall?
Aye.
The motion passes 4-0.
Okay, great. Now we come to item number 4, introduction to special guests. Do we have any special guests brought by anyone today? Hearing none, we'll move on. Item number 5, employee of the month. Who's presenting this today?
Madam Chair,
Go ahead.
Sorry, I
Mike.
think I'm getting an echo.
Well,
This is
it's fine.
So this is Michael Smith. The Employee of the Month was nominated, I believe, from your office. And it is Hans Muller from our division in the General Counsel's division. And I guess, commendation or recognition certificate, I will read. It states that the New Mexico Public Regulation Commission hereby recognizes Hans Muller as the NMPRC Employee of the Month for August 2022. And it states, whereas Mr. Hans Muller serves as attorney in the Office of General Counsel at the New Mexico Public Regulation Commission, and whereas Hans Muller has worked for the PRC for almost 3 years, and whereas his nomination states, Hans is crushing it, stepping up and helping fill in after various vacancies. Even with a new law clerk, we are still short-staffed at OGC with an attorney 2 and attorney 3 positions open. Hans has been doing an incredible job just in terms of sheer volume, exclamation point. Hans is pumping out product and still finding time to prepare, organize, and facilitate various Zoom meetings. Hans elected to stay on with the commission several months ago when he had an opportunity to leave the agency. This is the type of character that we should be recognizing in our Employee of the Month award. He deserves a heavy pat on the back. I think I heard someone interject there, but whereas Hans Muller continues to serve the PRC with dedication and great ability, now therefore be it resolved that the New Mexico Public Regulation Commission of the state of New Mexico congratulates Hans Muller on his selection as Employee of the Month for August 2022. This is issued under the seal of the commission at Santa Fe, New Mexico, this 10th day of August, 2022.
And Madam Chair, if I can just chime in, I am
Yes.
Hans's direct supervisor, and you know what the resolution says is, I actually didn't write the resolution, but it's very accurate as to some of the high points of what Hans has brought to us. But I just like to add, I mean, Hans is incredibly productive. He takes on a lot of work. He gets it done very quickly. I don't know how we would have gotten through this particular period of time, especially since Isaac's passing, without Hans, because Hans steps up in every way. And Hans also has very good organizational skills, and he's always looking toward the future, and sometimes getting out the rest of us in line in terms of making concrete plans for the future. And for instance, after Isaac passed, we were all devastated, and we didn't know how we were going to handle all of the administrative tasks. But Hans immediately put together a spreadsheet of the tasks that needed to be divided up. He was just very practical and helpful, and got us going at a time when we needed to get going immediately, because we really didn't have any time to wait. So Hans has really been just a great addition to OGC.
Thank you, Russell. Thank you, Mike, for your comments. Anybody else?
Madam Chair,
Okay, let's let Mike go first. I think I heard his voice, and then I'm not sure who I heard next, but I think I heard two voices from the hearing room. Michael, did you want to say more?
Yes, well, I just wanted to echo what Russell had said. Obviously, I've been out for significant periods. So I have not been involved with the fixes that Hans has been doing as much, but I'm, along with the rest of OGC, been the beneficiary of his incredible lifting of the weight that has been put on everybody, and I really have to express my appreciation for him stepping up and for the incredible performance that he has shown while carrying his own workload. It's really been quite impressive.
Thank you, Mike. Now, I think I heard Commissioner Byrd, is that right? First, and then Commissioner Vice Chair Mayesis. Okay, great. Thank you.
I'm not that I'm not that gruff and abrasive.
As you say. Okay.
Anyway, I think this is a well-deserved recognition for Hans. I'm really grateful for his initiative and most of all for him staying here at the agency. And so, Hans, congratulations, well-deserved. And I truly enjoy working with you. You add a lot of professionalism to the agency and a pretty good work ethic. So thanks again. That's all I had, Madam Chair.
Thank you, Vice Chair Meistus. Commissioner Byrd, did you say anything? Did you speak up there? Yes. Okay. Please go ahead.
Yes, ma'am. Thank you, Madam Chair. I echo my colleagues' sentiments, Hans, Mr. Mueller. You're an exceptional colleague, and I've enjoyed working with you. And even in serious debate that we have here, you bring levity, and such as the Hans Solo episode. And I want to say thank you. You know, if we're not enjoying our work, it's work. But if we can enjoy what we're doing, it's not work. And you bring enjoyment to this. And I want to say thank you for doing that. We've had a number of phone calls about issues and yeah, you're exceptional. And I really am glad you stayed with the agency. But wherever you end up in the future, I know you're going to succeed because you have the mindset to do so. Thank you, Madam Chair.
Thank you, Commissioner Byrd. I see Commissioner Fishman has something to say, of course. So take it away.
Now you sound like Commissioner Byrd.
Oh, I don't mean it.
Anyway, Hans, it's just been terrific to have you on board at the PRC, and whatever you've been asked to do, it just feels like you step into it and you get it done. And no one has to think about it. You're just going to get it done. And it's just incredible to have that kind of reliability. And boy, it just makes life a lot easier in what is a tough job at the PRC with all the stuff we have to keep track of and do. And it's just been a pleasure to have you on board. And congratulations. Could have been recognized sooner, I suppose. But, you know, maybe if we recognize you every month, you'll stay on board for years and years and years. And the agency will really benefit because, again, it's just terrific to have you to work with.
Thank you, Commissioner Fishman. Anybody else?
Yes, Commissioner Hall, this is Judy Amer. Yeah,
Yes,
everyone has said it so appropriately. Hans is so reliable, dependable, and, you know, willing to pitch in and do what is ever necessary. And we really appreciate you, Hans. And so I just want to let you know that you now have a dedicated parking spot at the PERA building.
Anywhere in Sandoval Garage.
Right. No, I mean, that was we used to give the employee of a month a parking spot at the PERA building, except I don't know if it ever happened. I think it was just something we talked about doing. But anyway, no, it's really amazing what Hans has been able to do working remotely. It really is.
Thank you, Judy. Anybody else? Commissioner Vicente Aguilar, did you have anything to say about Hans?
Yes. Thank you, Madam Chair.
Yes.
Well, I would like to take this opportunity to express my appreciation to every employee of the agency, and some of them, they have been nominated and they have been picked to be Employee of the Month, and they are at the top level. there's a tier, there's different tiers, and the top level are the employees that have been recognized, and Hans is definitely right there at the very top. And it was his personal and professional decision to help us while we were short-staffed, and that is tremendous. In my mind, that is tremendous. Thank you very much, Hans, for doing that, and we look forward to working with you the rest of the year. Thank you.
Thank you, Commissioner Vicente Aguilar. Does anybody else in the virtual audience have anything to say? I'm not seeing or hearing anything else. I would like to make a few comments. And that is that I just wanted to say, Hans, I truly, truly appreciate you as an employee. And I want to repeat the expression that I've heard from everybody, that we do hope you stay for a long time, even if we commissioners won't be here to enjoy the benefits of your work. We truly appreciate what you've been doing. And I want to say, I recall when you began work, and I watched you over time, and I've been so impressed, because there was never a time when you really seemed flustered or unprepared. You have really been quite an example of professionalism. Your work product is always to the point and well written and well reasoned, and it is not longer than it needs to be. Your brevity is really appreciated by me, at least. And however, I did notice that, when there was a matter that you felt needed stronger analysis, you put it in. You wrote more than you usually do, and it was very well reasoned. And I was glad. I was just really glad we have you. And I also want to express my appreciation for your decision to remain with us when you could have left. I know there are other interesting jobs out there. Ours is not the only one, but as it turned out, it was a time when we were really bereft, right immediately following your decision to stay. And I can't say how valuable you were to us, and how what a good thing that was. And I was very glad you were there. And when I think about all the attributes, the positive attributes that everyone's described, I have to, it makes me think back to one thing about you that I was very impressed with when I first met you, and that is that you're a former hockey player. And if everybody thinks about what hockey players have to do, you can see why Hans delivers so well in his job, because you really have to be an incredibly loyal team player. You have to be very quick on your feet. You have to be able to execute correctly, and you have to be fierce. And I think Hans is just a very excellent lawyer, because he's also a hockey player. So that's my take on it. Anyhow, thanks a lot, Hans. And if nobody else has anything to say to Hans, we'll move on. Next, we have public comment. Do we have any public commenters signed up?
Madam Chair?
Yes, Commissioner Bird.
Could we allow Mr. Mueller a response?
Oh, of course. I'm sorry. Please, Hans, would you like to say anything?
Yeah, thank you, Madam Chair and commissioners. I am humbled by all of your comments. I think the best thing is, of course, those comments are now recorded. I'll be downloading a copy of the YouTube video to my personal computer at some point. No, but I appreciate the sentiment and the comments that everybody has made. I'd just like to add that working with OGC with my division is really a blessing. We have a tremendous group that works well together and support each other. And that's difficult to find in any working environment. And I like to think here at the PRC as a whole, we have a really good working environment where people support each other. And it has been a privilege to work with this commission. Since I've worked with this commission for the majority of my time here, everyone has been very easy to deal with. And I have really enjoyed the opportunity to serve as legal counsel before you, but also working with everyone here at the PRC. So that was a big part of my decision to stay on. And we're getting through some tough times right now, but we're getting through them too. And that's because of everybody's effort, not just mine. So, but I thank you for the honor of Employee of the Month, and I look forward to serving the commission all the way up until the end of the year and beyond that. So thank you.
Thank you. Commissioner Byrd, but did you have something to say? I noticed your hand was up.
No, ma'am. Just thumbs up. Just thumbs up.
Oh, that was a thumb. Okay. All right, moving on. Public comment. Has anyone signed up for public comment? Mike or Russell, whoever's watching that?
I believe actually Hans gets that call.
Oh, huh.
I have had no phone calls or emails requesting public comment. If there is no one who has appeared publicly at the hearing room, there is nobody signed up for public comment today.
Fine. Thank you, Hans. All right. Next, we have consideration and approval of prior meeting minutes. We had Russell already explained that we are, in fact, approving the minutes of July 21st, 2022. Is that correct, Russell?
Madam Chair, I believe that was Hans who corrected
Oh,
that.
Hans, sorry.
Yes, the meeting minutes are for July 21st, since we met on the Thursday that week. And I did circulate a slight edited version of those minutes this morning.
Okay.
It was just a simple correction of a first name of Miss Trammell from the version that was originally circulated.
Okay.
That will be the version that we are approving.
Thank you, Hans.
But Madam Chair, that was a major correction because her name was listed as Bert. She's no Bert. But
You're right.
anyway, thank you, Hans.
Right. Thank you. Thank you very much. So let's see, we need to, are there any other comments before we take a vote? Hearing
Madam
none.
Chair, it requires a motion and-
What?
It requires a motion and second.
Yeah, I'll move to approve the minutes of the July 21st, 2022 open meeting.
Okay.
I'll
Second.
second.
Okay, we have a motion and a second. Let's take the roll call.
I'll start with Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas.
Aye.
Motion passes 5-0.
Thank you, Mike. Okay, moving on. We're at the consent action agenda. Mike, do you want to read out the cases?
Yes, the consent action items for this agenda are transportation matters consist of case 22-00184 TRM in the matter of the application of the County of Torrance, DBA Torrance County Ambulance service for reissuance of certificate number 43650 to provide ambulance service, and that's a potential order regarding the application. Case number 22-00184 TRM in the matter of the application of City of Socorro DBA City of Socorro Fire Department for reissuance of certificate numbers 01575.
Mike,
Yes.
did you say 185 or 184? I thought I heard you say 184. You want to repeat? Why don't you repeat that again? Because I think you said 184. Just start with number 2, 22-185.
Yes, 22-00185 TRM in the matter of the application of City of Socorro DBA City of Socorro Fire Department for reissuance of certificate number 01575 to provide ambulance service, and that's a potential order regarding the application. Case 22-00187 TRM in the matter of the application of Pueblo of Zuni DBA Zuni EMS for reissuance of certificate number 14437 to provide ambulance service. This is a potential order regarding the application. And then case 22-00204 TREN, and that's in the matter of the investigation of Flying C, T, and G wrecker services, and that's a potential order to show cause. The utility matters consist of one case, and that's case 22-00202 UT, and that's in the matter of the joint application for the location approval of the 2022 Corona generation expansion pursuant to the Public Utility Act, New Mexico statutes annotated section 6293, and Ancho Wind LLC, and the Ancho Wind LLC, Cowboy Mesa LLC, Guyanas Mountain Wind LLC, Mesa Canyons Wind LLC, Pattern SC Holdings LLC, Viento Loco LLC are the joint applicants. And that's a potential initial order appointing hearing examiner. And based on that, if there's a motion, we would need a motion and second for me to call the roll.
Hey, commissioners?
Madam Chair.
Yes, Chairman.
Move to approve the consent agenda as presented.
Thank you. I've got a motion. Do I have a second?
Second.
Thank you, Commissioner Fishman. So we have a motion and a second. Mike, any discussion on this? Any changes to the consent action agenda? Hearing none. Mike, can you please take the roll?
Commissioner Hall. Yes, Commissioner Hall.
Aye.
Commissioner Maestas.
Aye.
Commissioner Burt.
Aye.
Commissioner Fishman.
Aye.
And Commissioner Vicente Aguilar.
Aye.
The consent action items are approved by a vote of 5-0.
Thank you, Mike. So moving on to the regular action items. We have item number 21-00112 UT in the matter of the Commission's adoption of rules pursuant to the Community Solar Act. It's a potential order regarding Southwestern Public Service Company's motion to stay implementation of the rule. And we have Russell Fisk presenting it. Russell, would you like to proceed now?
Yes, Madam Chair. So this is the second motion for stay that has been filed in this docket. The first one was filed by SPS and EPE at the same time, around the same time as the 9 motions for rehearing on the order adopting rule were filed. That previous motion had requested a stay of implementation of the community solar program. This motion is just by SPS and requests a stay of implementation of the rule pending the pending appeal. But the SPS has brought of the two orders, the order adopting the rule and the order modifying the rule pursuant to the motions for rehearing. So I'm going to start, if you're following along with the memo, I'm just going to start at page 7, where the discussion of the proposed order starts, because discussing the proposed order will involve discussing the arguments that were made and how we're addressing them. So I'm just going to skip the parts of the memo that lay out in detail SPS's motion and the responses received from the joint commenters, which include REIA and some other groups, and a separate response filed by the City of Las Cruces. So I'm starting on page 7 because the order really summarizes all that, I think, adequately. Okay, so my recommendation is to deny the motion for stay. SPS presented the motion under the Tenneco factors, that is from a case that is usually cited and followed, including by the commission, and in a case that I had a few years ago, for the 4 factors to consider when considering a motion for stay. However, the first paragraph of findings, and this memo tracks the proposed order. The first paragraph of findings, or second paragraph of the commission's findings, would say, before addressing the Tenneco factors, the commission will address the threshold argument, which is made by in the response by the joint commenters and REIA, that as the community solar rule became effective on July 12th through publication in the New Mexico Register, the commission may not have the power to stay the rule's implementation. And they would say the commission finds that it does not have the power to stay the effectiveness of the rule, which could only be accomplished through another rulemaking proceeding under the State Rules Act. Then I go on to, the order would go on to say, if any person having presently exercisable rights under the rule were to come before the commission seeking to exercise such rights, the commission could not deny the exercise of such rights on the ground that the commission had stayed the rule. In other words, because it's a published rule, it is, it's an operative rule, and to the extent it gives any rights to any participants in the community solar program, the commission cannot unilaterally, not unilaterally, the commission cannot stay its operation without holding another rulemaking proceeding. So it is the law. It is on the books. However, because the next steps in the implementation process for the community solar program are for the commission to undertake, the proposed order would state that the commission will entertain the motion as requesting that the commission delay undertaking such steps pending the outcome of the appeal. In other words, the commission will entertain the motion as requesting a stay of implementation of the community solar program, which is what SPS and EB had asked for before. And the reason that is fair is that it's that I think the same result that you would get, or the same, it's basically the motion would be identical if it were phrased that way in terms of its impact, because the next steps to be taken are to be taken by the commission to really to get the bidding process going. And there really are, as far as I see, there are no rights of any party, of any potential participant in the program. That's a lot of P's. That could be exercised right now anyway. But I wanted to make it clear in this order that we agree with the joint commenters that we couldn't just, the commission couldn't simply state the effectiveness of the rule through an order. But at this point, all the steps that need to be taken are the commission. So the commission could consider delaying undertaking those steps until the appeal is finished. But as I said, my recommendation is not to do that and to deny the motion. And that the analysis applies the 4 technical factors as SPS apply those factors in its own motion. The first factor, and this is in this case, by far the most important, is that the commission would find that SPS has failed to demonstrate a likelihood of prevailing on the merits of its appeal. That's the first element of the technical factors, is that the party moving for a stay must demonstrate a likelihood of prevailing on the merits in the appeal itself. The first thing one of the main points that SPS represents or argues that it will prevail on is that SPS believes that the rule doesn't regulate subscriber organizations. Those are the organizations that operate community solar projects and enter into agreements with subscribers. Those are the people who would be seeking, access to community solar. The act does not require this heavy-handed approach that SPS alone advocated in the rulemaking proceeding. Even the other utilities didn't advocate such a sort of invasive approach to regulating these subscriber organizations. SPS's approach was similar to that of states such as, I believe, Maryland and Connecticut, and which have had low participation by subscriber organizations. The sorts of things that SPS was advocating for were that there be particular provisions and contracts and subscription agreements between the organizations and their subscribers, provisions for automatic, refunds upon request, things that could really hamper the operations and even the financing of community solar projects. So instead, the commission adopted a lighter approach focused on disclosure from subscription or from subscriber organizations to their subscribers and potential subscribers. That's something we were required to do by the rule and the Community Solar Act, and we didn't go far beyond that. Although we noted in our order, if we, during this initial 2-year period of the program, which really is in some senses, according to the act, like a pilot program, the commission may consider heavier regulation if there are certain problems that arise. So the commission would find that SPS is unlikely to prevail on that argument in the appeal because, one, the act does not require such a heavy-handed approach, and thus the commission's choice of a lighter level of regulation for subscriber organizations, since it's not contrary to the act, it's a policy decision within the commission's discretion. In other words, there are a range of policies that the commission could have chosen there, and it will be reviewed as such by the court. It'll be reviewed on an abuse of discretion standard of review, which is a very minimal level. In other words, this is where the commission has a lot of authority and a lot of room to make decisions within its discretion. Okay, I promise the discussions of the other issues will be shorter than that one. That was really the big one for SPS. SPS also makes a vague claim that the rule does not contain sufficient language to fulfill the act's requirement that the rule include grievance and enforcement procedures for subscribers against subscriber organizations. And the order would simply say, SPS has apparently overlooked the procedures provided in, and it gives the particular rule section. These procedures clearly comply with the act. And to the extent that SPS's challenge may be merely a difference in the preferred policy, again, the commission's policy choice is very likely to be upheld on the court's review because it's a decision within the commission's discretion. The next argument that was made by SPS concerned something that we've talked about quite a bit when we were discussing the order adopting the rule and the motions for rehearing, which is that SPS and the other utilities disagree with the commission's interpretation of the act when it comes to the calculation of solar bill credits. Those are the credits that appear on the utilities bill to subscribing ratepayers who subscribe to a community solar project. That actually delivers that credit actually delivers the monetary benefit of being a subscriber. But the utilities argued in the comments, and SPS argues here that the act should allow, that the rule should allow for deduction of transmission costs that are allocable to community solar projects from the credit. And the commission found, and the city of Las Cruces and its response concurs in its response to the motion, that the Act's express provision for the deduction of commission-approved distribution cost components, that's distribution cost components, that's quoting from the Act, from solar bill credits, and its omission of any mention of the deduction of transmission costs indicates the legislature's intent to prohibit any transmission cost deduction. This goes along with is pursuant to a canon of statutory construction. In other words, a sort of guideline for statutory construction that if certain items are listed or specifically mentioned, in this case, distribution costs, as something that could be deducted from the credit, but something else that you would expect to be listed with it, if it were allowable, like transmission costs, and transmission costs are not mentioned, then you can interpret that as an intentional omission by the legislature that is indicating that transmission costs are not deductible. So I think it's a clear interpretation of the statute. And then it would also say, the order would also say, it is difficult for the commission to conceive of any situation in which transmission costs might reasonably be considered to have been caused by a community solar project. On the contrary, community solar projects bring generation within the distribution level of the grid. So the main argument is that the statute is, we think, is quite clear that it can't be deducted, but also we see the reason why. The commission can see the reason why. These are projects that are generally at the distribution level. They should not involve additional transmission infrastructure. Okay, so moving to the next argument. SPS claims that the rule fails to include a mechanism for utilities to recover their administrative costs arising from the community solar program. Notice they came up. And the commission find that highly unlikely to exceed on appeal because it's simply false. As the city of Las Cruces points out, this claim is apparently the result of SPS's failure to notice that the commission, in its order on the motions for rehearing, added a rate rider mechanism to the rule to satisfy the requirement. So this is, they just missed this, I guess. This was something that hadn't been included in the rule, on the order adopting rule, but when it was pointed out by the utilities in their motion for hearing, we corrected that. This would be a rate rider mechanism for the utilities to quickly recover any costs of administration that arose from the community solar program, and the rider would be applicable only to its customers that were participating as subscribers. So it would honor the Act's requirement that that non-subscribing utility customers not subsidize any costs that arise from community solar. Now you may, some of you may be thinking about that 3% allowance for some subsidization, but that actually does not apply to the administrative costs. It applies to the solar bill credit. So I just want to clarify that. But again, the point is the mechanism that was provided in the motion, the order on rehearing, does exactly what it's supposed to do, and SPS simply seems not to have noticed that. It's odd. So another argument that SPS makes in favor of its argument that it was likely to prevail on appeal is that the rule's delegation of, and now I'm quoting from SPS's motion, the entirety of the project selection process to a third-party administrator renders the rule impermissibly vague. This order would have the commission find that that's highly unlikely to succeed on appeal. It's entirely without merit, this argument. The city of Las Cruces noted in its response in opposition to the motion that the rule provides an extremely detailed set of criteria to be considered, as well as specific point weighting for each criterion for the third-party administrator to apply. There's hardly any discretion there at all. I think you'll recall that's very detailed. And then, as the city also noted, to the extent that any questions arise that are not answered by the detailed provisions of the rule, the administrator or any participant in the process may raise such questions before the commission. That is also from a provision, the same provision of the rule. So that argument is really baseless, I would say.
So, Madam Chair.
Commissioner Fishman.
Yeah, Russell, I recall hearing during the process that of the various community solar programs around the nation, that some of the ones that were most successful in being most effectively administrated were through third-party administrators. Do you happen to know if that's just a faulty memory on my part, or is that the situation as you understand it?
Commissioner Fishman, that could well be true. I just do not recall that, and I don't recall if it was in the comments or if it was just a remark that was made. You know, there's I don't recall. But it could very well be correct.
Just checking in to see if my memory is any good anymore.
Well, my memory is even worse, so I'm not the person to check with, I guess. Okay, so we're almost to the end of this first element. It's a long element, this one about likelihood of success on the merits, because it goes through almost all the arguments SPS is making on appeal, but we're almost finished. One of SPS's arguments is that concerns the commission's use of the team, the Community Solar Action Team. And here it was SPS and EPE raised these issues really as a series of like rhetorical questions in their motion for stay of implementation that was I previously mentioned. And now that the claims are even more vague. And for one thing, there's no reference to any particular statute that they think may have been violated or particular rule. And what is most baffling is that, and the order would say this, that SPS refers to the team's recommendations as non-public. And the order would say, the reason the SPS is aware of the team's recommendations to the commission is that they were made publicly in commission orders issued throughout the proceeding and discussions of such recommendations in open meetings. They could hardly be more public. The irony of SPS's claim, and I'm just pretty much reading from the order here, is that the commission's process in this rulemaking proceeding, that the claim that the process was opaque, is that the irony of that is that SPS applies this claim to the commission's efforts to be even more transparent than usual and more transparent than applicable law requires. SPS ambiguously references alleged failures by the commission to follow proper notice and comment procedures. Again, like I said, they don't cite to any statute or rule. I mean, I don't even know how these claims apply to the team. They're that vague and unsubstantiated. So the order would then go on to actually restate the commission's response to the SPS and EPE request for procedural clarifications and motion for stay, because that addressed I had to guess at what the issues would be were that they raised that time. But one of the things that was addressed there was that if there are any ex parte concerns, because there were two members of staff who were also members of the team, staff, while the record was open, the commission could and any commissioners and OGC could speak freely with those staff members without any concerns of ex parte communications. And this notes that after the record closed, there were no more team discussions involving staff members. So there was no ex parte problem. And also that staff, staff's comments, its recommendations and responses to other comments were all in the record. There were no team discussions during or after the closing of the record that involved staff recommendations or staff responses to other recommendations and comments that were made to the team directly outside of written comments. So everyone had a chance to see all of staff's input in the comments. So that was already something that had been clarified in the previous order, but I would simply restate it again here in this proposed order. One clarification that wasn't made before, but I wanted to include it here in case this is one of their concerns. Like I said, the claims are so vague that I have to guess at what their concerns might be. And I think it's important to provide for the commission to provide clarification where there might be a valid concern. I'm not sure there's a valid concern here in terms of I'm not sure that there's there's a genuine concern here. I think this may simply be a frivolous argument, but in any event. This order would also, discuss Arthur O'Donnell, saying he's been an invaluable resource to the commission. Of course, all the participants have been well aware of his participation, providing advice to the commission and describing, his status as a contract consultant, and then as a pursuant to an appointment to the U.S. Department of Energy. And would this order would note the commission has no legal obligation to disclose the substance of Mr. O'Donnell's advice to the commission. This is quoting New Mexico Supreme Court case from 2006, holding that the commission has no obligation to disclose the substance of advice that it receives from its advisory staff. Mr. O'Donnell is a member of the commission's advisory staff. He's advising the commission directly on both on this matter and other matters like the interconnection rule. And there's no legal obligation to disclose any of the substance of Mr. O'Donnell's advice, but insofar as it's part of the team's recommendations, it has been disclosed. In other words, this goes to the point that the commission has actually been more transparent than it had to be in this matter, just because it was a matter where we had a special team set up, and that team was very helpful to the commission because the team developed expertise and policy knowledge that could transmit to the commission without the commission having to get into every detail of community solar. It was very helpful, I think. Okay, so that's it for all of the arguments as to why, SPS's arguments as to why it was likely to prevail on the appeal. Yes. I thought I heard my name. Did someone say my name? Okay.
Russell,
Yes.
actually, I was muted, but I am saying your name now. There's some interference that I keep hearing while you're talking, and
I hear it too.
if everyone could mute, and it looks like it's a phone. I'm looking at the gallery screen, and I don't know. Commissioner Byrd, you're not muted. If you could maybe mute. And I think Commissioner Vicente Aguilar, you don't appear to be muted either. If you guys could just put yourselves on mute, maybe we could get rid of that, what sounds like reverberation. Mr. Byrd, can you put yourself on mute? Are you muted?
I'm muted.
Okay, well, I guess it doesn't appear correctly on my screen.
I show the same thing on my screen, that the two phone numbers, I think the two call-in phone calls are not muted, but I don't know. Anyhow, I don't hear it anymore. Do you?
No, I don't.
Okay, good.
So I think it's fixed. All right, thanks. Let's go ahead. Oh,
Madam Chair,
yes, Commissioner Vicente Aguilar.
my phone was muted. The technology that we're using is not always accurate.
Yeah.
Thank you.
Thank you. I appreciate you telling me that. And it's borne out by the same thing happening to Commissioner Byrd. So, but in any case, whatever was going on has stopped. So we're okay now. So go ahead. Please proceed, Russell.
Okay, so the proposed order would, having gone through all those arguments, would conclude that the first Tenneco factor has not been established by SPS. In other words, the commission finds that SPS is not likely to proceed to prevail in the appeal. The second Tenneco factor requires that SPS show that it will suffer irreparable harm if the stay is not granted. And SPS's arguments were quite weak on this. SPS pointed to the uncertainty, the challenges it was making to the rule, and how the difficulties that could arise, not only to itself, but to customers and subscriber organizations if it prevailed. So the irreparable harm, most of the argument rested on the assumption that SPS would prevail, which the commission rejects. There wasn't really anything that seemed that the SPS would lose in the meantime that would for instance, even if it were found to be, if the commission's rule is upheld. In other words, so SPS pointed to potential loss of goodwill by customer confusion if there was a change, if SPS eventually prevailed on its claim with regard to, say, the transmission costs and solar bill credit, the regulation of subscriber organizations. And one thing that the city of Las Cruces and the joint commenters point out is oddly, this is SPS making arguments on behalf of its customers, even though, and on behalf of subscriber organizations, even though the subscriber organizations are sort of well represented in comments and also in the motion. In the response to the motion by the joint commenters and REA, they not that they have an official representation of that position, but they're the ones who they're among those who represent that position in many cases in the comments in opposition to the utility, and they are in favor of the rule and not appealing it. So it's a bit odd. SPS's argument there really doesn't make much sense. And the joint commenters also said that because SPS is a monopoly, any potential loss of quote unquote goodwill from its customers, their argument is just baffling, right? Will not result in the loss of any customers or revenue because that's a monopoly. And the commission, the order would state that the commission further agrees with the joint commenters and the city that any alleged uncertainty about the status of the rule is due to SPS's decision to file the appeal. Again, SPS notes all the things that are called into question by its own appeal. So the order would conclude that SPS is not likely to suffer irreparable harm if the stay is not granted. That's the second factor. Moving on to the third factor under the Tenneco analysis. The order would find that SPS has failed to demonstrate that other interested persons will not suffer substantial harm if the stay is granted. So that's the third Tenneco factor, is that the party moving for a stay has to show that other persons interested in the matter will not suffer substantial harm if the stay is granted. The order would say the commission concurs with the city of Las Cruces that substantial harm will result from the delay in benefits to utility customers who are currently unable to procure renewable generation resources of their own and would like to take advantage of the community solar program to achieve greenhouse gas emission reductions and potential energy cost savings. I'm really quoting the city there because they did a great job of enunciating that harm. I think a lot of people in the state have been waiting a long time for this, and this delay could be up to a delay based on an appeal could be 2 years or more. I mean, I looked at the most recent decision in one of my cases before the Supreme Court, and it took a little over 2 years from filing to final decision. So that definitely would cause substantial harm to a lot of people within the state who are interested in participating in community solar, as well as these subscriber organizations that would like to participate. Finally, the fourth factor under Tenneco, the fourth factor is that whether I don't know exactly how it's phrased, but whether granting the stay would cause harm to whether harm would ensue to the public interest. That's how it's phrased. The joint commenters and REA and the city, again, they provided very informative and just very, very good arguments in their responses. Noted that the Community Solar Act, evinces an urgency on the part of the legislature to implement the program. There was a deadline for the commission to adopt a rule of April 1st of this year. And the act also provides for this relatively short initial pilot period for the program. It doesn't call it a pilot period, but it's clear that it is because it requires at the end of this period, which ends with a report to the legislature by the commission on November 1st, 2024, reviewing the initial performance of the act. That's one indication that this is kind of an initial pilot to see, what the problems are, what the success is, what the successes are, et cetera. The commission is also under the act required to, I think it's by April of that year, determine a new statewide cap of the total size of the program. So the commission will be evaluating whether the 200 megawatt cap is adequate, and if it needs to be, if it or any new cap needs to be reallocated among the utilities. So this definitely a period of learning about how the program will operate here in New Mexico, its success rates and et cetera. So the order would say a stay of the program pending appeal is likely to result in a delay in implementation of the program of 2 years or more, given the current docket of the court. Granting the stay would essentially erase the initial period of the program, contrary to the clear intent of the legislature. In other words, there really wouldn't be any information because the first 2 years would be, like I said, essentially have been stayed. There would have been no progress and no program implemented. So that's why those are the reasons that I recommend that the commission adopt the proposed order, which would deny the motion for stay. And I will take any questions.
Thank you, Russell. That was very thorough and very informative. I really appreciate the detail you went into to explain the compliance with the program, and it's with the 4 factors of the test. So I'd like to open up to commissioners. If the commissioners have any questions or comments, Commissioner Fishman.
Madam Chair, I just want to say that the legislation creates some level of competition for the utilities. So I understand why they're not in a rush to have community solar happen. But I think that the team, as we call it, and the commission, and under the leadership of Commissioner Maestas, did a fantastic job of getting folks involved, getting all the input we could possibly get, making it as transparent as we could possibly make it, and getting something sensible in place that we can learn from over the next couple of years as we implement it. I totally agree with all of Russell's arguments. I think he did a great job of laying it out. And with that, I would move the order.
I'll second that.
Thank you, Commissioner Fishman and Vice Chair Maestas. Do we have any further discussion on this motion?
Madam Chair.
Yes, Vice Chair Maestas.
Thank you. I just have a few remarks under discussion. And yes, I think Russell did a very thorough job in explaining the basis for the order that we are going to vote on. I think the respondents to the motion to stay the community solar rule pending appeal and our own general counsel's office have more than eloquently and persuasively explained why we should deny the move-in's request for a stay. In particular, I echo our general counsel's statement that some of the move-in's assertions reveal either their misunderstanding of the law or their readiness to pursue legally groundless arguments. Certainly, I believe that the commission's actions in completing this rulemaking were thorough and exhausted. Intelligence and resourcefulness of our advisory utilities and general counsel staff, the maximizing of staff and commission resources involving many stakeholders in multiple pre-rulemaking workshops, and the timely use of critical consulting services, and the addressing of every aspect of the legislature's mandate in the community solar law, and doing so in record time, are nothing short of a marvel. And that effort and accomplishment should be applauded. Instead, it is being met with baseless and frankly meritless assertions that the work was insufficient or inappropriate. Our internal team of experts used every ounce of their expertise in crafting this rule and followed every rule to make sure they did so without endangering the very work they were so passionately engaged in. I truly believe that the work and results that went into the community solar rule shines through the efforts to cast a cloud over the bright future this rule will help to empower. Finally, I have to say that even more galling than the movement's meritless assertions in their obvious and cynical effort to delay or derail an initiative that could be so beneficial to so many New Mexicans, a rule and a program that will help our state's economy and energy transition to be a more just and equitable one by allowing more people, especially low to moderate income populations, to enjoy the cost and environmental benefits of solar power. In my opinion, this effort to delay this unprecedented program is sad and disappointing, and I will vote to deny the motion to stay with the public interest in mind. Thank you, Madam Chair.
Well, thank you, Vice Chair Maestas. Those comments are very eloquent as well, and I think they go directly to the heart of this of the nature of this motion, of this request for a stay. And I really appreciate your comments. Any other commissioners have any comments?
Madam Chair.
Yes, Commissioner Byrd.
Thank you. I have some questions of Russell. First question, you stated that you don't think we have the authority to grant the stay because we can't suspend the rules. Is that correct?
Yes, Commissioner Byrd. Yes, exactly. So we can say the motion would be considered in a different form, which has a similar effect, just because the next steps to be taken are steps by the commission. I'll let you complete your question. I'm sorry.
Yeah. Okay. I agree the arguments are vague and some of the arguments are actually conjecture, which probably aren't arguments at all. Correct. Should have been thrown out. To say we can second guess what our Supreme Court would do, I'd rather bet on who's going to win the Super Bowl. So in the event that it is brought before the court and SPS is victorious in 2 years, what could be the fallout, the repercussion if we hadn't stayed now?
Commissioner Byrd, that's a good question. So it depends on which arguments are accepted by SPS. For instance, if the court accepts the argument that there are certain transmission costs that could be allocated to some subscribers, as on the theory that, one, the statute doesn't prohibit that, which I think it clearly does prohibit that. And two, that there are some transmission costs that are caused by a particular community solar project, which I don't see how that can happen. That there might have to be retroactive adjustments made to solar bill credits, the credits that may have been that should have had transmission costs deducted that didn't. The SPS raised a concern about retroactive rate making by that. I don't consider that to be retroactive rate making problem because it would be pursuant to a court order finding that part of the rule was invalid. So the retroactive rate making is a prohibition generally on the commission from setting rates with a retroactive effect. This would be the court saying this rule was wrong all along. So I think those adjustments could be made. That's one adjustment that there might be if they prevailed on that. If they prevailed, say on me take up the other one. Sorry, I'm trying to remember what would be a pertinent argument here. On say the use of a third-party administrator. I find, I mean, I just find it so doubtful, so unlikely, but that they would. But if they did, gee, I'm not sure. I'm not sure what they've had. We'd have to, stop using one going forward. I don't think there'd be any retroactive adjustment there. I don't think they would. The court. I mean, generally, when the court overturns a commission order, the order usually is in the form of it says that the order on appeal is overturned, and it can be so we'd have to undertake another rulemaking, I believe, to although we could the possibility is we could reaffirm the rule except for what has been overturned, but we'd have to undertake another rulemaking, which we have to do in 2 years anyway, and is already provided for in the rule. So let me think of anything else. Let me look at the arguments just to consider that more closely. So generally, a court decision overturning a commission order is only prospective, but the commission has in the past made adjustments to the extent that they seem to be implicated by the order. So the commission could do that with regard to, like I said, solar bill credits. With regard to the subscriber organization or level of regulation, again, that would involve the commission undertaking another rulemaking at that time, at the time of the decision. And again, that'd be 2024, probably about the time that the commission would already have begun actually a second rulemaking to address the requirements of the legislature, particularly with regard to resetting and reallocating a statewide cap. So that rulemaking would then be informed by the court's decision. Does that answer your question? I think, Commissioner Byrd, are there any other particular items that you would like me to discuss?
No, thank you, Mr. Fisk. There's so much vagueness on both sides. I think there's something more to it, and I don't know what it is. I will support the order based on your knowledge that we don't have the authority to suspend the rule at this point anyway. However, I suspect we're going to find something new in the future on this. Thank you, Madam Chair.
Thank you, Commissioner Byrd. Any comments from any other commissioners?
Madam Chair.
Madam Chair.
Yes, Commissioner Vicente Aguilar and then Commissioner Fishman.
Thank you. I have some questions for Mr. Fisk. You stated in your discussion that this is the second request for stay from SPS. Is that correct?
Yes, Commissioner Vicente Aguilar, that's correct.
During the rulemaking proceeding, do you have any information whether SPS was given the opportunity to participate in the process?
Oh, yes. Commissioner Vicente Aguilar, SPS filed initial written comments, response comments, I believe, and also I believe they filed reply comments. There were 3 rounds of comments, and they filed I believe they filed all 3 types of comments. They also filed a motion for rehearing along with 8 other participants. So those comments were all addressed. I believe some of them were even adopted. Yes, they participated very much in the process, in the formal process, and also I believe in the informal process of workshops that occurred before the NOPR was issued.
Okay, can you remind me how the commission made a decision when SBS requested a rehearing?
Yes, let me just look at I just have to look back at that order to see specifically. Just let me find that. Okay, so I'm looking at, I'm looking at the order. You don't have it before you, but I have it before me now. So the commission's order, I think issued in May of 2020 this year. There's an order partially granting 5 motions for rehearing and denying 4 other motions, and also addressing SPS's and EPE's request for procedural clarifications and for stay of implementation. So this dealt with a lot of issues. With regard to SPS's arguments, let's see, I just have to look and remember where they were. I know that SPS did raise the issue, let me see here, the issue of the level of regulation of subscriber organizations. Yes, so for instance, I'm looking at the order now. P&M and SPS criticized the commission's decision in the order adopting rule, the decision to refrain from extensive regulation of subscriber organizations. SPS had argued that the rule lacks necessary consumer protections. When they say consumers, they're talking about subscribers to consumer community solar projects. They rejected, the commission had given a number of reasons in its order adopting rule as to why the commission was not adopting a more stringent regulatory regime. And one of those was a reference to the commission's own strained resources, which is a perfectly valid argument to raise. Now I just have to find the commission's response there. Sorry, it's a long order. So the commission responded to that. Let's see here. Sorry, I just have to go through this long order. It's a very long order. Okay, so in that motion, in that order, the team made recommendations to the commission regarding SPS's motion and other motions. So the response, the commission's findings included. So again, SPS, I'll just give you a summary here. Sorry, I'm refreshing my memory, but looking at this order. The SPS raised largely the same arguments as motion for hearing and the motion for stay of implementation of the program that filed back then in April of this year. They made criticisms of the team approach, but they weren't specific criticisms that cited any law. And the commission rejected that for the reasons I described today, because I actually, like I said, incorporated those two paragraphs of the order from May right into this order. The SPS had also raised an objection to the commission's efforts to implement the program before the rule had been published. There was a workshop held with regard to the calculation of the solar bill credit, and there was a separate docket set up, 22-0020-UT. This is an argument that regarding implementation is not raised again in SPS's motion to stay pending appeal, because that was part of their motion to stay implementation of the program pending the finalization of the rulemaking by publication of the rule. So that argument is actually stale at this point. But the commission addressed it then, addressed that issue then, implementation. So that was another issue as SPS. Let's see. Let's see what else it is. Oh, the SPS raised the same arguments concerning interconnection costs actually they raised same argument that I just discussed with regard to the inclusion of interconnect. I'm sorry, I'm getting confused. They raised a couple of different arguments. One, an argument regarding administrative costs for that the rule lacked a mechanism for recovery of administrative costs incurred by the utilities. And in response to that, that's what I was talking about with regard to the argument that the fact that SPS has raised the same argument now is they seem not to have noticed that the commission listened to its argument in the motion for a hearing and did change the rule accordingly, providing a rate rider mechanism by which the utilities could recover their administrative costs from subscribing utility customers only. So they raised that then. We addressed it in the rule, providing specifically for that. And still they raised it again as if we hadn't done anything. Then with regard to interconnection costs, they had asked for a specific mechanism for recovery of interconnection costs. That's the cost of connecting a community solar project to the grid, which involves an interconnection study, and then to determine the cost, and then in some instances may require extensive or expensive upgrades to that particular portion of the grid. How the commission responded to that was that the utilities currently bill interconnection applicants for the costs of interconnection studies and the cost of interconnection under the commission's rules for interconnection. The same practice should apply here. There's no special mechanism needed. In other words, the utility can go ahead and issue an invoice to the community solar project, and then the community solar rule does provide that community solar project, the subscriber organization, or the developer, et cetera, can come to the commission and then petition for some of those costs to be shared to the extent that they can show that those costs will benefit other community solar programs or non-subscribing utility customers. So that was how that was addressed. Let me see if there were a few more arguments that they made. I think that was it for addressing SPS's arguments there. But like I said, there were some similar arguments made that the commission, similar arguments to those being made now, that the commission rejected on the same grounds as the commission does now, with regard to the level of regulation. And then there was also, but there's explicitly an example of an argument that SPS made that resulted in a change to the rule. And now SPS seems not to have noticed that was done, as per its request. So I hope does that answer your question, Commissioner Vicente Aguilar? Sorry, it was kind of a rambling response, but I had to go back to the order from May.
Thank you very much, Russell. When I was a paralegal, usually all the court proceedings are stapled on the left side of the binder in sequence. So those are my experience as to why, for this particular case, SPS is requesting a second motion for stay. I think maybe some of your questions were not answered clearly. I'm not too sure, but I think our general counsel's office did a good job as far as giving the opportunity to the parties and see if we can move forward on this Community Solar Act. So thank you very much, Russell. I appreciate it.
Thank you, Commissioner Vicente Aguilar. Any comments from any other commissioners? Oh, Commissioner Fishman, sorry, I forgot.
Oh, no problem. I just wanted to say that there's a lot of different viewpoints that were brought to the table in this rule. And, no matter what you do, there's going to be a lot of things that, people maybe wish for our initial going out might have been done a little bit differently. There's a lot of things that I might have done a little bit differently, but I think that what's important is that we've taken in all the input we can. Everything that we've done is acceptable no matter what we do, no matter how we frame this rule going out, there's going to be changes. We're going to learn lessons. And learning those lessons quickly, I think, is more important than sitting around a table and arguing details that we can't know what's going to happen in terms of actual implementation until we actually go out there and try it. And so, again, I think we've done an outstanding job of getting in all the input and putting together something that takes account of it all and reasonably meets all the expectations of the legislature. So with that, I would like to take it to a vote.
Thank you, Commissioner Fishman. I would like to make a few comments and then I would agree to vote.
Okay, I'll sit through that, I promise.
Well, I'll be quick. I simply wanted to echo the comments of you and Commissioner Fishman, especially not Commissioner Vice Chair Maestas, and add a few of my own, which is that under the circumstances where the legislature required a deadline by which this rule had to be passed, and a circumstance where this is a novel design of the way of delivering renewable energy to our state, community solar. It's not as if we've ever done this before, and not that many other states have achieved it. I am extremely proud of how our team here at the commission performed, led quite impressively and ably by a commissioner who was new to the job, really, at the time this all began, Vice Chair Maestas. I think what we have accomplished in this short period of time with the quality of the rule that we have is absolutely outstanding. And I understand the a utility subject to this rule having to make adjustments in the way they operate. I understand how they want to try to achieve ends that will serve their needs great more than anybody else's, has to go through those steps. And I understand that their lawyers are put in the position of having to cobble together arguments out of whatever the facts happen to be. But I wholeheartedly agree with our general counsel's opinion of these arguments and his analysis. I think it just looks like a case where the attorney's put in a position of having to throw things on the wall and hope they stick. But from my experience, and I've seen more than a few cases where this argument has to be plotted through the Tenneco factors. Their arguments are weak to non-existent. And since I know Commissioner Byrd was wondering, well, how do you really just, how can you second guess? But you can. It's not second guessing when the facts support your side. And in this case, the tremendous amount of transparency and inclusiveness in the with all the stakeholders and the careful attention to listening to stakeholders' needs and listening to them and that's demonstrated here, as a matter of fact, in this one instance, where the commission listened to an objection and made a change to the rule as a result of SPS's comments. I think the facts speak for themselves. I do agree that the SPS is not likely to prevail on the merits, and I think we've ably ticked off all the other requirements that show that our action to deny the stay would be found quite acceptable and quite reasonable as a discharge of our duties. So with that, I would like to ask Mike to take the roll call. Or Hans.
I can do that. Sorry, I was unmuting.
You are Mike. Hi. Okay.
No problem.
Okay.
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
and Commissioner Byrd.
Aye.
Motion passes 5-0.
Thank you, Mike. Okay, so let's move on to, let's see, the next item on the agenda is item number 8, in case number 22-00020 UT, in the matter of the implementation and administration of a community solar program. And this is a discussion item, and the discussion would be regarding the contract entered into with Incline Incorporated for services as a program administrator. Russell, to be presented by Russell Fisk and Renata Perry Gallon. Russell or Renata, are you ready to present on this matter?
Yes, Madam Chair. So I provided a copy of the contract with Incline. This is something that, I believe Commissioner Maestas has repeatedly referred to as the process has been going on in various open meetings, including last week's open meeting, about the request for proposals process for this position as the third-party administrator of the program. The major task of the third-party administrator, not the only task, but the major task, is actually operating the bidding process for the selection process for projects, of receiving bids and analyzing bids from community solar developers who hope to become subscriber organizations, or who may turn the project over to a subscriber organization to actually build and operate community solar projects. So as I noted in the discussion just now of the motion for stay, that's a process that is the process. The rule provides in great detail for that process. Tells the administrator what to do with regard to the size of how to determine which projects are admitted, are selected to move forward to the interconnection stage, keeping a wait list, the criteria, the detailed criteria, and weighting of each criteria for selection.
Excuse me, Russell. Sorry to interrupt. We're getting that feedback again. So if anybody's forgotten to mute, can you please mute? And I'll do that too. Okay, thanks. Please proceed, Russell.
So this contract was entered into with Incline, which is a consulting firm that has experience in the area of administering community solar projects in other states. If you want more information on that, I think possibly Commissioner Maestas would have more information on Incline's background. But we actually had a meeting with them, a kickoff meeting yesterday via Zoom, and they're very experienced in this area, and they will help make the bidding process more. They'll help bring in bidders in terms of helping them get through the process and And so that's going to be the bidding process is going to be their and selection process is going to be their main task. The contract describes in the scope of duties that task that's most of it. And there are some other tasks, ongoing tasks afterward that the incline can assist the commission in. When it comes to actually, decisions under the rule, administering the rule itself, as opposed to administering the program, most of that will be the commission's duty. So there's some things that are not delegable, but as the Community Solar, this Community Solar Act really assigns two major categories of duties to the commission. One is the issuance of a rule and the administration of a rule, which involves, that involves things that have to be done by the commission. But then there's administration of a program, an ongoing program of where, money is collected and from fees and specific applications are made and the selection is done. But there isn't a whole lot of discretion for the administrator, as I said, because under the rule, it's a very specific process, there's a lot of detail as to how projects will be selected. So I hope I didn't feel like I rambled a little bit on that. I can stand for any questions, and Renata can as well, with regard to the RFP process that was used. But it seems like Incline is going to be a very good, very helpful, experienced sort of partner helping the commission navigate the administration of the program itself.
Thank you, Russell. So is your intention for Renata to also present on this matter? Or
Madam Chair,
or is it
no,
she here
I just have
to answer
Renata
questions?
is present for any questions about
I see.
the process, because it was an RFP, procurement process. So.
Okay, well, looking at the scope of work, it looks like these are very important steps that they're going to be carrying out. Do any other commissioners have any comments or questions about the content of this contract?
Madam Chair?
Yeah.
Yeah, I just, I'm not going to go over what Russell has already mentioned, but I just want to assure all the community solar program advocates out there that we are definitely moving forward with implementing this program. As Russell mentioned yesterday, we had a very comprehensive kickoff with Incline Inc. As the new community solar program administrator. We met the entire team. We answered some questions from the Incline team. And I'm just very excited to report that we're going to begin in earnest the launching of the program leading up to a call for projects. And this could be basically done, or the program could be ready in early December. So I'm just very excited. This is a major milestone in the implementation of the community solar program. And we have a very experienced and capable team in Incline. So anyway, I just wanted to report out that we did have a very successful meeting yesterday, and we are moving forward. Thank you, Madam Chair.
Thank you, Vice Chair Maestas. That's very interesting, and I'm delighted to see this scope of work, and I'm delighted to hear your confidence in their experience, and I'm just delighted to hear that we're moving forward, and before the end of the year, we'll be able to go live, I guess. And this is very exciting. So moving on, we'll go to the communications portion of our agenda. Are there any communications with Chief of Staff?
He's coming up.
Okay.
Madam Chair.
Yes, Commissioner Vicente Aguilar.
The previous discussion on the contract for community solar, Are you stating for the public meeting that it was already approved?
Yes, Commissioner Vicente Aguilar, this was an RFP process that was discussed with regard to, when the rule itself was being presented to the commission. And I recall that Commissioner Maestas has presented on it a number of times in the open meeting. So it is an RFP process, sort of like with the State Rural Universal Service Fund Administrator. It's a process of selection that the commission does not, stays out of, in the sense that whoever selected according to the criteria of the RFP, receives the contract. So it has already been entered into.
So Russell, this the contract was approved?
This is with Incline Inc. They're a
Yes.
consulting firm that has experience in administering community solar programs.
Yes, my question is, was this contract approved?
It was, yes, it was approved through the RFP process. It was, and that process was approved by the commission, but there hasn't been a commission approval because, like I said, like this, and also the SRUSF administrator, an RFP process for these positions does not involve commission approval, because the commission wouldn't be overruling the requirement, the criteria of the RFP. So community solar team members, including Arthur O'Donnell, were involved in reviewing the applications that were received and proceeding according to the criteria of the RFP.
Russell, it looks like, excuse me, Commissioner Vicente Aguilar, it looks like Renata would like to make a comment to you. Is that correct, Renata?
Yes, thank you. Commissioner Vicente Aguilar and Chair Hall and commissioners. This RFP was subject to New Mexico Procurement Code. So we followed New Mexico Procurement Code, and an evaluation committee was brought forth, and they evaluated based on the criteria, and it was awarded based on the criteria in the RFP. So it follows New Mexico Procurement Code in that a determination was made by the evaluation committee. It has to go to our chief procurement officer, who at the time was Miranda Mascarenas, who reviewed and approved the evaluation committee's determination.
Okay, Commissioner Vicente Aguilar, do you have any further questions, or otherwise we can? What's that?
I understand. Yes, Madam Chair, I understand what Renata does as far as doing her work. That's not my question. My question goes back to the commissioners and Russell Fisk. What you're stating for the record is that this does not require a commission approval. Is that what you're stating?
Yes, that's correct, Commissioner Vicente Aguilar, because the commission did approve the rule, and the team would go forward with an RFP process. And then once the RFP process is started, then it's a process that doesn't involve commission approval. Like I said, just like the SRUSF administrator, it's similar. It's another administrator, and it's done according to an RFP process. And then we report to the commission who is chosen to be the administrator according to that process.
That's a State Rural Universal Fund administrator.
Yes, I mentioned that because it's a very similar example. There are criteria, the telecom staff is involved in the evaluation team in that case. Here you had community solar team members involved in the evaluation according to the criteria in the RFP. And the RFP process is one that has to proceed according to its own criteria. There'd be no input from the commission having approved the process to go forward. and the rule to select a third party administrator, the commission wouldn't be overruling the evaluation under those criteria, because then the RFP process would not have been followed.
So we are contracting with an administrator, and while the rulemaking proceeding is being challenged by SPS through the Supreme Court. Is that clear? Is that what I understand?
Yes, and as the commission decided today, the appeal, the commission does not consider the appeal does not believe it's likely to be successful. So the commission has not stayed. And for applying the other technical factors, the commission has not stayed the effectiveness of the rule or the implementation of the program. So it will go forward. And one of the major initial steps is to conduct this bidding process for community solar subscriber organizations who would like to build and operate the community solar projects, and that will be administered by this third party administrator. So yes, it will go forward unless I assume that SPS will appeal the commission just as it has appealed the order adopting rule and the order on rehearing. It will, I'm guessing, appeal the commission's denial of the stay to the court, and the court will then have a limited level review of the commission's order. The court could come out the other way, but that was what the analysis today was all about, was why we don't expect the court to find that a stay should be granted. So the program will go forward during the pendency of the appeal unless the court does something unexpected.
Russell, I've never encountered this type of activity before, where the rulemaking the proceeding of the rulemaking has been challenged by one or two parties, and on a parallel to that, we are executing a contract to administer the program. That doesn't seem right to me.
Commissioner Vicente Aguilar, it is right because it's in accordance with the commission's decision today. The commission does not want to stay the operation of the program, the implementation of the program. And if the commission did not contract with a third-party administrator to begin, the next steps that are involved in implementation of the program, then the commission would be effectively granting the stay. So it's consistent with the commission's decision today. I will say this, the community solar program and the community solar act are different the act is different from other acts that are other statutes that are administered by the commission. And that, like I said, there are two types of administration that are going on here. Usually with like the Public Utility Act or the New Mexico Telecommunications Act, administering means administering the rule and adjudication, issuing a rule and performing adjudication under the rule, considering applications under a rule. That's present here. But there's also an actual ongoing program which involves a budget and application fees and ongoing practical administrative issues. And usually we don't have that. So you haven't seen that before. The fact that there is this program administrative function that the commission is delegating largely, at least in terms of the bidding and selection process, to a third-party administrator. So that is a little different in that sense. But again, it's consistent with the idea, like usually if the commission decides not to stay a commission decision or commission, which could be an order adopting rule, that means that the rule becomes operative. But that's all it means, or the order is operative, and that's all it means pending the appeal. Here, that's the case. The rule will be operative. unless the court issues a stay. The rule will be operative. But also the program itself, the administration of a program, which is something new, will go forward as well, because the commission, decided that today.
General Counsel for the commissioners, you feel that this was not a courtesy call to have a discussion about the potential approval of the contract for administrating the community solar. Is that what I'm reading from you, Mr. Fisk?
I'm not sure what that question means, but I would say this. It's like I said, because it was pursuant to an RFP process, there's no commission action to be taken on it. Because the commission action would either be superfluous or would be interfering with the RFP process. Commissioner Maestas has discussed this RFP process before in open meetings. And then in last week's open meeting, he mentioned that, a contract had been entered into with Incline. This is just to make sure the commission is fully informed of the outcome of that process.
Well, I hope that SPS is listening on this for this particular meeting, because I'm one commissioner that was left out of the loop for the Zoom meeting that occurred yesterday, and in the past, we've always discussed potential contracts amongst all the commissioners and to have everybody's input. And I guess I will just go ahead and conclude my comments based on that. Thank you.
Thank you, Commissioner Vicente Aguilar. So I think we'll proceed now with communications with Chief of Staff.
Good morning, Madam Chair and members of the commission. It's nice to see everybody this morning. I really don't have anything of significance to report this morning. And I know you have a couple other items on your agenda, but happy to talk about any issues you have or would like to discuss.
Thank you, Mr. Probst. Do any of the commissioners have any questions for our Chief of Staff?
Madam Chair.
Yes, Vice Chair Maestas.
Thank you. Wayne, what's the status of our advisory engineering position? I know that we've been advertising it. Are we doing anything different? Have we had any candidates that are worthy of interviewing? Do we need to take any other unusual steps?
Madam Chair.
Can you show a little enthusiasm?
Oh, I'm enthusiastic, Madam Chair, and members of the commission. I desperately want to fill all of those advisory positions. The short answer to your question, unfortunately, Mr. Vice Chair, is no. I don't think we've had any serious applications. If Renee or Sarah are online and I'm incorrect with that, they can certainly correct me. I don't know what else we can do other than what we have done. I think we've hit all of the places that I can think of and that HR can think of in terms of advertising that position, in terms of thinking differently, Madam Chair and members of the commission. It may be that we need to start thinking about what we're considering doing with the economist position, and that is entering into a contract as opposed to hiring a full-time employee. I know the preference is to hire a full-time employee. That certainly is my preference, and we're going to continue to try to hire full-time employees for all of the positions, including the economist position. But it may be that a short-term contract is something we need to consider. But finding somebody to do that is going to be challenging. It would be my guess as well. We always thought, Madam Chair and members of the commission, I think we always kind of thought that the engineer would be the most difficult one to fill, and it's certainly proving to be the case. And so I'm sorry I don't have a more positive report, Madam Chair.
Thank you, Wayne. I wanted to find out what the transition was for returning employees to work, if we're getting any direction from the governor or general services. I realize, we have limited office space and we can't accommodate not even, I think, over half of our employees, but is there a plan in place to maybe have supervisors come in, or can you kind of give us an update on that?
Sure. Madam Chair and members of the commission, Vice Chair Maestas, thank you for that call or for that question. I'm not aware of any new direction from SPO on that issue. I obviously know a lot of people in state government and have conversations with other people who run state agencies that are longtime acquaintances. I think it's sort of being left up, as I understand it, to agencies. I know I was talking to somebody, I can't remember which agency it was the other day, but I believe it was actually someone who worked at DFA, and they're, as I understand it, DFA is doing half work in office and half remote for their employees. I heard a rumor, I haven't confirmed this. I heard it a month or so ago that GSD was requiring all of their employees to return to in-person work. I'll try to see if I can confirm that and let you know. So Madam Chair and members of the commission, maybe what I should do is try to get a better answer than that for the next meeting and report to you, and also report on where we're at. I would say that I sense that there are more people in the office than there were maybe 6 months or so ago. That's just my impression. I'm here at least 4 days a week, oftentimes 5 days a week. So I do sense that there are more people coming into the office, but being up on the third floor, as you know, is kind of isolating. It's isolating. So there may be staff that are coming in that I'm not even aware of. But let me, Madam Chair, because it is a good question, let me try to give you a better answer next week, if that's okay.
Okay, thank you, Wayne. Madam Chair, that's all I had.
Okay, thank you, Commissioner Vice Chair, and thank you, Wayne. Do any other commissioners have any questions for Mr. Probst?
Madam Chair.
Oh, yes, Commissioner Vicente Aguilar.
Thank you. This is for our Chief of Staff, Probst. The numbers are still surging in New Mexico as far as COVID is concerned. Wearing masks is still a mandate by the Navajo Nation president on the Navajo Nation. My assistant, Jennifer Baca, became very ill 2 weeks ago. She informed Human Resource Department that she caught COVID. I'm talking about 2 weeks ago. And asking employees to come back to the building is wrong. Our health and safety is a high priority. And that's my information for our Chief of Staff to consider. Thank you, Madam Chair.
Thank you, Commissioner Vicente Aguilar. Let's see, I see Renee Kepler has her hand up. Renee, would you like to make a comment or ask a question?
Yes. Good morning, Madam Chair and Commissioners. I was listening in when the questions arose to Chief of Staff from Vice Chair Maestas. Currently, we have received 2 applications for the engineering position, and both of those did not have any type of utility experience, and we have not received anything further. We have these positions advertised on LinkedIn as well as NARUC. And we also did advertise them in the newspaper quite some time back. So we are still working with LinkedIn to see if we can get further out there, but we just haven't been successful with those positions. And in regards to employees returning back to work, We have not received any direction from state personnel or the governor's office regarding employees returning back to work. It is at the discretion of the agency. And so as far as I know, like Wayne said, there are some agencies that have staff, half day or splitting their time throughout the week. So I just wanted to confirm that we have not received any information. And once we do, I will send it out to staff.
Thank you, Renee. That's very helpful. That's informative on both those points. I really appreciate it. Thank you very much.
Andrew, you're welcome.
Yeah. Any other commissioners have any questions or comments or questions for our chief of staff? Hearing none. I think we can move on to communications with general counsel.
Madam Chair, I guess another gift for Commissioner Byrd. We don't have anything today.
Okay, fine. Thank you very much. Communications with commissioners? Nobody
Madam Chair,
has.
just real quick.
Yes, Commissioner Byrd.
Yeah, I'm going to draw attention to Mr. Borman.
All right, I see him.
I just want to say that he's trying to help out his cat there, Veruca. She's very disabled and covered with warts, and
I believe Commissioner Byrd is referring to this particular image that
No, that's a beautiful kitty. I'm talking about the one behind your head.
Oh, that's a painting in our house.
Oh, I see. You mean the picture behind you?
Yes.
Yeah.
Oh,
Check
I
it
see.
out.
I like it. I like it, by the way. Okay, is that the extent of your comment, Commissioner Byrd?
That is all the
Oh.
value I brought.
Well, I appreciate you pointing out some of the finer aesthetics that we have to consider sometimes here in the commission. Thank you. All right. Let's see. So we're at the point. Oh, wait, we have now we have, it looks like, an update from accounting advisor John Olmsted. That seems to be part of communications with commissioners. Did a certain commissioner, I believe Commissioner Fishman, did you ask that we have John communicate, I guess, information that you would like to communicate through him? And you're muted. Can't hear a word you're saying.
If I get off mute, I bet you could hear me. Yeah, and Commissioner Maestas, I know a couple of weeks back had wanted an update, and I think it's good that we all are familiar with all of the things that John is working on.
Great. Well, John, would you like to proceed with your presentation? I think you're muted too.
There we go.
There.
Oh, okay. There we go. Can I be heard clearly?
Yes, I can hear you.
Oh, good. All right. Well, there are like four major categories of work that I have been involved with since I got here. The biggest one is basically a summary and a standardization of information regarding the 3 IOUs in New Mexico. I've put those together, and I've actually presented an earlier version of that summarization for P&M in a public meeting about 5-6 weeks ago. What I have done is I have incorporated changes or change requests that I have gotten in terms of things like font size and organization size of charts and graphics. And I have prepared PDFs for each of the 3 IOUs, as well as a comparison of all 3 IOUs compared to a regional average that I get from the EIA, and I have presented those PDFs to the IT department, to the PIO, and to the acting utility engineer for posting up to the website. As near as I can tell, it has not yet been done, but it is. We're proceeding on the forward with getting those PDFs up to the website. There is an addition that was requested at, was either the last public hearing or the hearing before, where we would be looking at the amount of renewables and renewables, or actually production or generation by type for each of the IOUs, and including that in an addendum to those PDFs. So the PDFs currently for each IOU are 6 pages. We would add another page or 2 to look at the generation by type. We had been the commissioners had, and I believe it was Commissioner Byrd had mentioned that PNM had a has their information on their website concerning pretty much instantaneous renewable output at the time, and that maybe we could deal with that. I've investigated that, and I've come to the conclusion that it's probably better to look at taking that information from either from either 550 filings or the annual reports that they have, that excuse me, that each IOU has, that we could get that information. I haven't finished putting all of that together, but and there are still some other issues with respect to that, especially concerning battery storage, which is often, which will ultimately be used to support the addition of incremental renewables. And then we will put that all together in a table and add it to the end of each individual IOU's PDF. Secondly, I have been asked to look at how renewable resources regulation is handled in states that have very aggressive either carbon capture or, no, excuse me, not carbon capture, but where there was where states are really aggressively moving towards renewables, specifically states like California, Hawaii, Oregon, Colorado to some extent, and New Mexico, and look at how each of those states regulates the siting and the connection of those renewable resources to the grid. That work is still ongoing, and as part of all of that work, I've also been involved in looking at other technologies with respect to battery storage and different types of battery technology, because a lot of the current battery technologies generally revolve around lithium ion, batteries, and that requires rare earths. And up until recently, there are very few sources for lithium that are, as a matter of fact, I think there's only one source for raw lithium available in the entire country. But recently there have been discoveries of lithium and plans to extract that lithium out of areas in the Salton Sea area in California. Additionally, there are other technologies that might prove more interesting and potentially less hazardous, because dealing with the rare earths and the water requirements for extracting and mining of lithium. We've been looking at technologies with respect to gravity batteries, which is basically very much like a gigantic version of a pendulum clock or a grandfather clock, where you charge up the batteries by running motors and pulling up a very large weight, whether it's iron or concrete or up either a shaft or a structure, and then to charge up the battery. So when the weight's all the way at the top, it can be used as and the motor that charges it can be switched to turn it into a generator, and can be used to generate power for a certain number of hours. They cite them. There are a few companies that are looking at that. There is one installation that I am aware of that is currently being built in Louisiana, and several others that are being built in the Middle East, in Europe, and also in Africa. And
so John, this is Commissioner Fishman. Madam Chair?
Yes, Commissioner Fishman, please proceed.
I would prefer not to get talking into a lot of the technologies that are out there. I think we should focus on the projects that you have and the progress that we're making on them. And what I wanted to, just a couple quick questions on the utility profiles.
Yes.
Before we move on to the other projects you're working on, is do we have any kind of date that's been that you've found that when that will be posted on our website?
I have talked to I talked to Miguel in IT this morning, and he's still trying to get me a final answer with respect to when that's likely to be the case, but I'm hoping it would be within the next week or two.
Okay, and so Miguel, if you're listening in, certainly when you've got a date, please let John and the commission know. There's some very interesting information, particularly generated that, John, you'd put together kind of on your own initiative in terms of the way you organized it, which I thought was terrific. And, it was interesting to see the differences in costs between our various utilities, particularly for residential customers, and in comparison to national averages. And that's the kind of information that when it's out there, I think folks will find very illuminating and interesting, including our commissioners. So, I'm very anxious to get it out there and sort of see the kind of discussion that it generates. In terms of the renewables, you were just talking about annual reports, and it would be the annual, like if you do annual reports, it would be like last year's percent of renewable generation out of the total. Is that what you're talking about?
Yes, and it may very well be that that this information is put together as part of the Rule 550 filings, or at least the second part of the Rule 550 filings that are filed. It usually is the end of April in each year, looking at the prior year. So there will be kind of a lag, but the individual, each individual utility, I believe, has some I don't know if you call it a widget, but they have some sort of app on their website that actually can that say, like Commissioner Byrd had been mentioning, that PNM says, at this particular moment, renewables are 18% or 22%, and what it's been over the last several days. And each, I think, utility is looking at it from a slightly different perspective, but you can get more recent information from the from websites, but it's not vetted and filed. And so to get official information, I think it's better to look at information that is already filed, and I believe that information is filed in the second part of the Rule 550 filings for each year.
So without getting into too much detail here, sorry, we just got some rain starting and the cat needed to be let in. And it's a cat that is, Brad, all due respect to your cat, but this is the cutest cat in the world that we've got here. And I will not put it in danger. But at any rate, to me, what last year's renewable generation is not current enough, because the utilities are bringing new resources online now, and then those numbers are changing rapidly. And I'm thinking quarterly data at a minimum would be the best. And if we don't have good sources of data, I know that the utilities can pull it together quite easily, and that we could just ask for a quarterly report to update this public reporting. And if that's the best way to do that, let us know, and we'll just make that information request, and that way the utilities will vet it. We'll know it's vetted, and it will be relatively current. And it will be looking at say a quarter, 3 months period of time, as opposed to looking at just little slices of a few hours here or a day or two there. It'll be a more kind of comprehensive look at the overall renewable generation, which I think is most informative for the public and probably for the commission as well. Am I making sense?
Yes, you are, and I can continue to. I'll reach out and see what I can do. Try to see if I can, and they can pull that information together, and and how easy it would be.
Let me know in the next week or so, and then if we need to follow up with a specific request to the utilities, we can do that.
I will try to get back to you by Friday of this week.
Okay, terrific. Thank you.
Okay. Go ahead, Commissioner Fishman.
No, I was going to say, go ahead.
You're finished. Okay, so then does that conclude John's presentation for the moment then until you get that extra information compiled in there? Is that what you're getting at here now?
No,
Yes.
I think John should go ahead. He's got some other projects to talk about.
Okay, I just wanted to mention that we're getting close on the noon hour, and if we could possibly wrap up by then, we could maybe take a brief break before we, at noon, before we embark on the Southwest Power Pool presentation that will commence after that. So, John, is it possible to be done by noon? You've got.
Yes, I'm essentially done now. We've talked about some of the other research projects that I'm putting together with respect to how other states are handling the aggressive introduction of renewable reduction in their states. I'm hoping to have a report put together for the commissioners by the end of this month.
Okay.
And
that sounds excellent. That would be very informative. I appreciate that.
And in terms of some of the other technologies, I'm just fascinated, and I can provide information on those technologies to commissioners either on request or in a formal report.
Okay.
And that being the case, my presentation is pretty much over.
Okay, wonderful. Thank you, John, for accommodating us. And Steve, are you satisfied with the length, with the content he's covered? Okay.
Yeah, well, just one other question on the research that you're doing with other jurisdictions on renewables implementation. I'd had a particular interest in how they're handling all the implications for pricing of electricity amongst customer classes, because a lot of those dynamics change dramatically when you're bringing on a lot of renewables. So I just wanted to check in, John.
Okay, I think I am looking at that as one of the aspects. There are a lot of concurrent technology implementations that have to be done, not the least of which is you need to have quicker metering available, specifically whether it's an AMI or or full two-way telemetric metering, so that you can provide signals to customers on the, on when and how renewables are about, and when the costs of production are extremely high. So they'd mentioned last week in the meeting we had with respect to Sandia National Labs, they were saying, hey, it very may well be that in order to get decent response, you're going to have extremely high differentials between pricing periods, between periods of high cost and periods of low cost, in order to get customers, whether it be residences, businesses, or industries, to make capital investments in technologies that will ensure that you are you're shaving the peaks and filling the valleys, as it were, trying to be and essentially trying to optimize your generation and transmission and distribution assets. That may take a little bit more time, but I still think that at least in terms of how basic regulation is going to be handled, I can do a first draft report for that again by the end of this month.
Okay.
Terrific. Thank you, John.
All right. Well, thank you very much, commissioners.
Thank you very much, John. I appreciate it. Okay. Does anybody have any other communications among commissioners at this point?
Madam Chair.
Yes.
Yeah, I
My
just wanted to recommend that in future updates from John, that he maybe submit a written report, and that way he doesn't really have to present the whole thing. We can just ask questions about the report itself.
That's a good idea. Thank you, Commissioner, Vice Chair Maestas. I was thinking the same thing because there's such a wealth of information. I like to have it in written form so I can digest it beforehand and then ask questions. I like that. Good thought. So I propose we take a 15-minute break.
Madam Chair.
Or yes, Commissioner Byrd.
SPP is
yeah.
doing a presentation. The gentleman Antoine has to be off at 1. 1 our time.
Oh, I see. Well, how about a 5-minute break then? I think we need a bit of a break. But
long enough to go to the,
You gotcha.
But just in case, I want to make sure we get our questions in and stuff.
I absolutely appreciate that. And I've been looking forward to it all morning. So we'll take a 5-minute break and be right back at noon. Okay.
Sounds good.
Thanks, folks. Okay, it's 12:01. I think we'll resume. We have next a presentation by the Southwest Power Pool. It's entitled SPP Update, New Resource Adequacy Policies. Let's see, Commissioner Byrd, did you place this on the agenda, and would you like to introduce the speaker?
Sure. So SPP has recently increased their reserve margin from 12 to 15%. And Mr. Antoine Lucas is here to explain the process that led us to that decision. And I see he's on, so I'm just killing air here. So Mr. Lucas.
All right. Thank you, Commissioner Byrd, and good afternoon to everyone here today on the call. So as Commissioner Byrd mentioned, I'm Antoine Lucas, SVP's Vice President of Engineering, with my primary responsibilities being regional and interregional long-term planning.
Mr. Lucas, could you possibly raise your volume a little bit?
Let's see. Okay, I'm going to try it here with my technology, and I'll try and raise my voice a bit as well. Is that
okay?
Better?
Yes, that is. Thank you very much.
All right. So I'm responsible for our regional and interregional planning, as well as our tariff services for generator interconnection, transmission service, and then also our resource adequacy, which I'm here to speak with you all about today. In this presentation, I do cover two policies that we recently had approved, but I will focus more on the planning reserve margin policy, if that's the one that this group is most interested in as we move forward. Next slide, please. Okay, I'll start out with just a really brief overview of SPP. I'm not sure if everyone on the call is familiar with us, but then we'll jump right into the policies. Next slide, please. One more. Okay, so here you can kind of see the SPP footprint in the 14 state territory that we cover. Some partial coverage in states, just like in New Mexico. But our service territory is more than 500,000 square miles, and we serve more than 17.5 customers across this footprint that you can see here. There are more than 800 generating plants within SPP, as well as more than 5,000 substations. So pretty substantial region that we cover. And I think that'll be relevant for some of the discussion later in the presentation. Next slide, please. This really shows you a breakdown of the membership within SPP. Currently, we have, I think actually the number is 113 members now. We just had a new one join. But the real important takeaway here is just the diversity of the different types of members that we have throughout the SPP footprint. And we think that's really important because, as you can see, with so many different types of sectors, GNTs, IOUs, municipals, state agencies, and others, that the policies that we develop are going to have very different impacts on those different parties. But through utilization of our stakeholder process, we believe that it gives us an opportunity to develop some much stronger policies by having that voice from so many different entities and working with them to try and mold solutions that fit the many rather than just the few. Next slide, please. Okay, so let's jump into the RA policy discussion and let's focus on reliability, which is really what the resource adequacy discussion is all about. Next slide, please. The first of the two policies we'll discuss is performance-based accreditation. And this is just for conventional generating resources, and the recommendation that was approved by both the Regional State Committee as well as the SPP board. Next slide. So just as a very quick primer for accreditation is simply just how much of the capacity from a specific generating unit do we expect to be able to count on to meet our reliability needs under the most constrained system conditions. And in SPP, we define those most constrained system conditions as the winter and the summer.
And Mr. Lucas, just as a preliminary question, accreditation is performed by by whom?
So it's met through processes described in SPP's tariff and business practices, but it's a process that does have activities that are being performed by the load responsible entities, those that are responsible for serving the load, and that also own the generators that are being accredited themselves.
And who does the accreditation for purposes of, is this accreditation that's provided by the power pool itself, or is it a federal accreditation, or what kind of accreditation are we talking about?
It is through the power pool's requirements. And this slide is actually going to talk a little bit about how we do it today.
Thank you.
So currently today, we just perform generator capability testing. When I say we, it's actually the generator owners that are within our load responsible entity. So for instance, in the summer, a generator is required to demonstrate the maximum capacity that they can achieve in running that generator for a single hour during that specific season. And that generator is expected to be able to meet that requirement for at least 4 hours. And essentially whatever amount that generator can meet, we would accredit that generator at that level. So for instance, if you had a 100 megawatt generator, that's its nameplate capacity. If during its summer testing, it's able to achieve 100 megawatts, then we would consider that resource accredited at its full capacity. Now, one of the drawbacks of this approach is it really doesn't consider the actual performance of the generator when called upon in real time, not just a test and the actual system operations. That information currently isn't captured. And what we found is with the fleet of resources that we have in SPP, especially some of those advanced age resources, they struggle to be able to meet those requirements at times and have outages. And we know that impacts our confidence around reliability. So, and that's primarily the reason why we considered this policy for performance-based accreditation. How could we better identify what a resource really can be counted on to do? And then how can we make the accreditation reflect that? And then allocate that appropriately to all of the generators throughout the region. So next slide. Okay, and that does bring us to performance-based accreditation, which really does differentiate generators based on their reliability performance. So as you would expect, just from the description, generators that perform well, and that definition for performing well is really based upon whether or not the resources are available and actually can produce when called upon, versus resources that may have higher outage rates or have derates to their capacity due to any types of limitations that would prevent that resource from being able to generate. Also further, going by a resource approach to the allocation, you're able to then allocate the results of that resource performance to specific generators and generator owners or load responsible entities, rather than spreading those impacts across the full generation fleet. We'll talk a little bit more about what that is and how that works in the presentation. So changing to this performance-based accreditation rather than just a testing approach, it doesn't create any additional capacity, but what it does do is identify the resources that perform better and give them more credit for that, and then also identifies the resources that don't perform as well, and it actually lowers the credit that they receive, and of course that does have an impact on the particular entities who own the resources in those fleets, and hopefully can influence some decisions that will improve performance of resources. Next
So
slide.
can I ask a question?
Sure.
What was the genesis of switching to this methodology of performance-based accreditation? Is the need for more research, for better resource, better reliability, I assume is what you were.
That's correct. Better reliability. We do try and track closely to our real-time system operations, and we use that as a feedback loop to get a better understanding of the availability of resources in real time. And what we found is that availability of resources tend to be much less than what we accredit them for, and identified that as a gap in the process that could adversely impact reliability. And this is an effort to mend that gap.
I see. Thank you very much.
All right. Next slide, please. Okay, so just talking a little bit about the benefits, which Commissioner Hall, I think you touched on already. So it really does value the conventional resources that are the most reliable and available to perform when our system operators need them. We also think it creates an incentive for underperforming resources to improve. And that incentive is primarily for investment and maintenance on resources to keep those generators in best possible condition to be able to perform. But I think it also provides an incentive for those resources that have high accreditation, that are performing well, for the owners of those resources to keep them in that condition as those resources age over time. It also ensures the appropriate capacity value to meet the planning reserve margin requirement itself. So, you know, if you have a lot of what I call paper megawatts that units are not likely to be able to actually produce, if you're counting those megawatts against your requirement, that's really not something that helps us in a real-time system operations condition. And then it also provides the capability to meet the various system needs that we have across the different seasons. So question we always get about this is, well, how do you treat the resources when things happen outside of the generator management's control? And this would not hold things like natural disasters or unexpected events against a resource, things that are really out of the ordinary and out of their control. This is primarily based on management control type factors that impact a resource's performance. Next slide, please.
Chair.
Okay, is there questions?
Yeah, well, just the.
Commissioner Byrd, I'm sorry, I was muted. I'll recognize you. Please go ahead.
Thank you. We're not getting the bottom of the slides all the time. So
I noticed that.
We miss a few words. So I think Patrick's running it, if he could adjust.
Yeah.
Yep, looks great. Thank you.
Great. Thank you very much. I appreciate that.
Okay.
Okay, go ahead, Mr. Lucas.
Okay, thank you. This slide essentially shows the implementation timeline that was adopted by the SPP Regional State Committee as well as the SPP Board. And under this timeline, what would happen is there would be a gradual phase in of this new methodology or approach, which kind of blends what we have today with the testing methodology, along with this performance-based methodology in quarters over each of 4 years starting in 2024. And so this was intended to give load responsible entities who own these generators the time they felt like they needed to be able to address the impacts associated with this change in resource accreditation. And then, of course, we would use the remainder of this year and next year, really doing all the data gathering that's necessary to perform all of the calculations and get everyone comfortable with the new policy. Okay, next slide, please. And this really just shows you the vote that was taken by the RSC and also the board, as well as the results. So it was, these were both, well, the RSC was a unanimous vote, and the board vote is actually a private vote. So, but it did pass. Okay, so this is really just a summary on performance-based accreditation. The next topic will be the planning reserve margin requirement itself. So I'll pause here if there are any questions around performance-based accreditation before moving on to the second topic. Okay. All right, hearing none, we can move forward. All right, one more slide, please. The planning reserve margin. Okay, so let's talk about the planning reserve margin and what is it? The planning reserve margin, the planning reserve margin itself is really just the incremental generation that we have above our forecasted peak load. So if you have 1,000 megawatt system and you have 1,150 megawatts of generation, got a planning reserve margin there of 15%. But we go further from that to say not just what you have, but we try and determine how much is required, or how much studies and analysis and other factors suggest is actually needed to maintain reliability. And so the planning reserve margin is designed to determine that amount of generating capacity that you need to have to maintain reliability during forecasted peak conditions. And we are looking forward in the future, so planning horizon. We study 2 years in the future as well as 5 years in the future. And our analysis is done pursuant to a reliability target. And the reliability target we use is pretty much an industry standard that is used primarily by some of our regulatory bodies. And it is a loss of load expectation of no more than 1 day in 10 years experiencing a loss of load. And that'll be relevant later in the presentation. Next slide, please. All right, so where are we today with our planning reserve margin? So SPP, at least up until our most recent round of meetings with the RSC and the board, our planning reserve margin was at 12%. And this again is a measure of the capacity that we're determined is needed to maintain reliability for our forecasted summer peak. As I mentioned on the prior slide, SPP uses what's called a loss of load expectation analysis to determine this planning reserve margin requirement. And all loss of load expectation study is it's a probabilistic assessment where we're looking at the generation that SPP expects to have available, and then probabilities of losses to that generation matched up against what our load forecast is, and then considering probabilities of that load varying higher and lower. And when you're comparing those two, you're looking for any period of time when the load exceeds the generation that's available. And that would signify to us that that would be a loss of load scenario. And if it's within a 10-year horizon, that would meet your 1 in 10. So I try to simplify that discussion, but there are thousands of simulations, and there are thousands of simulations that are ongoing, simultaneously evaluating these different scenarios to come to this conclusion. Now, something that's I think interesting and really subject to change in SPP's policy today is our planning reserve margin requirement is only enforceable in the summer season. Now, we do have a task force, the improved resource adequacy task force, I believe it is, the IRATF, that is evaluating having an enforceable requirement in the winter as well. Now, we still do the calculations and the analysis for the winter. It's just that the winter is what we call an obligation because it does not include deficiency payments if entities are unable to demonstrate that they have adequate resources to meet that winter requirement. But again, I expect that that's likely to change with the outcome of the IRATF's recommendations and work.
Mr. Lucas, I just had a short question. I'm just wondering what's the seasonal difference that would dictate having a requirement in summer and merely an obligation in winter at the present?
So historically, the challenges that we faced in the SPP footprint or region have been all in the summer. There used to be a much larger gap between summer peaks and winter peaks. And by having enough resources to meet your summer peak, you're usually in a pretty good position to meet your winter peak, which was already lower as well. Mm-hmm. Now, what has happened over time is the SPP footprint has grown, farther north. And also, I think some of the impacts of things like electrification have really picked up. We have a lot more parts of the community that are, using things like heat pumps that are transitioning to more use of electricity. And we've even seen some of our summer peaking utilities see much, much smaller gaps between their winter and summer peaks. Mm. And so our policy is starting to catch up to things that have been changing gradually over time.
I see. Thank you. That's very clear.
Okay, next slide, please. Okay, so this slide is essentially showing that, so one thing to clarify, each year when we do our resource adequacy report, We're evaluating the current position of SPP and its load responsible entities as it relates to their generation reserves. And we use that information in the snapshot to then determine, based on that, what's the outlook for our planning reserve margin itself. And that's what this represents. And you can see that based on the information we know today, the planning reserve margin is gradually decreasing year over year from 22%, where we are today, down to a forecasted 13.6% in 2027. The yellow dotted line represents where we were with the 12% requirement itself. And so you look at this, you do see a trend that the planning reserve margin is decreasing year over year. And the primary reasons for that is we are seeing a lot more load growth throughout the footprint, but we're also seeing significant amounts of retirements of fossil fuel fired generating resources as well that are contributing to this. But whenever we show this slide, we always want to make sure that people understand and recognize that this forecast does not necessarily always track well with what we see in real-time operations. I think our next slide should touch on that. So let's go to the next slide, please. Okay, maybe it's the next one. Well, let's talk a little bit about some of the drivers and the risk associated with this decreasing planning reserve margin. So one of the drivers is we have seen a large influx of renewables, which has created a bit more volatility around the availability of energy from resources. As I mentioned before, lots of generation retirements as well, and those generating retirements have primarily been through more controllable generating resources. Also an increased probability of outages due to extreme temperatures and fuel supply issues. So each of the last summers and winters, we've seen some more extreme conditions than we've seen historically. And then changing load shapes and volatility. So the impacts of electrification are changing the way that people are using the system and when the demands actually take place on the system. And then also just persistent operational issues and capacity shortfalls that we've seen in recent years. And the next slide, I think, is going to touch on some of those. Let's go to the next slide, please. Okay, so this chart is one that, at least I think it's an interesting chart. You may beg to differ, but the first curve, the purple curve at the top, represents our planning reserve margin. So this is what we expect to see from accredited generation that's available year over year in SPP. If you look down below that at the navy blue line, there are a couple of points that I want you to focus on. One is the lowest point in 2019. If you look at that gap between, and that blue line, that represents the capacity margin that was actually available in real-time operations. So if you look at the big gap between the blue line and the purple line, that's telling you that we planned or expected, based on our accreditation approaches, to have much more generation that was actually available to our operators in real time for reliability purposes. In the very next year, 2020, you see a smaller gap between those two curves, but there's still a pretty significant gap there. Looks like about 6 points on the scale. So moving forward, we start to forecast a little bit. We're looking forward at what we would expect to see based on those two trends. One being the worst case, that's the 2019 gap. One being the best case, the 2020 gap. So the best case scenario, forecasting that and extrapolating that forward, in the green line, you can show that over time, even in our best case, we're expected we would have very significant gap or fewer resources that are available to our operators in real time to manage the system. The maroon line is showing if that worst case trend continued. And then, of course, the Carolina blue there is just the average between the two. Now, those are open.
Mr. Lucas, I just have a question. So best case scenario is when you have the smallest gap between actual and the planning reserve margin?
That's right. That's the smallest error between the forecast and the actual.
Okay, and so that means that the regional transmission organization is able to maximize the use of the resources with the least amount of risk at the moment in any case. Is that what that means?
That's correct.
Okay.
That's correct.
Thank
more
you.
access to more resources in the event we have reliability issues.
Okay, thank you.
Okay, you can see the orange line there. It represents what we call an energy emergency alert. That's the point in time when our operators are, they've essentially exhausted their generating resource options, and they are essentially getting ready to exhaust their reserves. And then, of course, the red line at the bottom is when, you no longer have your reserve margin, whether it's operating reserves or the longer term reserves, and we're having to shed load to meet requirements. So you can kind of see in that worst case scenario, we're well below both of those lines. And on average, we're in a pretty critical situation if you were to extrapolate some of those same conditions forward. And these are some of the drivers for the need for the recommendation to increase the requirement. Let's go to the next slide, talk about it a little more from a different lens. So this is a slide that shows the number of events that SPP has had to call in some form or another to give people notice that we're having periods of time where we have very limited generating resources, and we're having to operate the system more conservatively as a result of that, those limited resources that are available to us. Quite a few events, if you just look at the different numbers there, conservative operations and blue and yellow resource alerts, those are kind of the earlier periods of resource deficiencies. And then you start getting into what we call the emergency energy alerts, or the EEAs, which get more severe as the number go up from an EEA 1 to 2 to a 3. And you can see the types of events that we've had over the years, and see that in each year, over the last few years, we've had quite a few, well into the hundreds. Next slide, please. Okay, so what I just covered kind of compares some of the forecast historically to what we see in real-time operations. But this slide is talking more about some of our forward-looking analysis that we've done most recently for the outlook for the summer of 2023, so the summer of next year. And we performed several loss of load expectation studies, varying those key assumptions that we talked about, like generator outage rates, as well as availability of demand response programs on the load side of the equation. And we also looked at different levels of operating reserves that would be available to our system operators. And across that range of studies, we saw that the planning reserve margin requirement ranged anywhere from about 13% to 18%. 13% again being more of your best case scenario, some of the lightest or least constraining conditions. And then 18% when we really wanted to stress the system, the level of generation margin or planning reserve margin that we would need there. So we also considered some of the current things that we see happening in real-time operations, as well as some of the trends that are telling us where the industry is headed. And in this additional analysis, we looked at things like, this increase in operational events associated with scarce generating capacity that I just discussed on the last couple of slides, as well as the growing deployment of energy limited resources like wind, solar, and also storage. And then the changing load shapes that we're starting to see across the system due to electrification. And when we looked at all those different factors and looking at a case that is not, too extreme, but also not too favorable, a more balanced look at those different scenarios, we came to 15% as being a good number to target for next summer. And within our stakeholder discussions, there was a general acceptance that 15% definitely made sense as the proper number based on the analysis. Really, most of the debate that took place in the stakeholder process was just around how quickly do you make the transition. And so in our consideration as the RTO, the primary thing we were focused on is the risk that we would live with during any transition and moving from the 12% where we are today to the 15% where we have recommended and recently attained approval for. And I'll show you a little bit more about that risk profile on the upcoming slides. Let's go to the next slide, please. Okay, so this slide, it scares a lot of people away because there's a lot of stuff going on it, but I'm going to try to be as clear, but also brief in going through this as I can be. This graphic is essentially showing some of the outcomes that we saw when we performed our loss of load expectation studies or analysis across, our best case scenario and our worst case scenarios. And on the left y-axis over there, you can see the number of days that our study is telling us that we would have a loss of load event over a 10-year period. And so remember, as we discussed before, the industry standard is a 1 day in 10 years. So anything above 1 day in 10, that's what's in pink. We kind of call that that's the area that you don't want to be in. On the right side, y-axis there in purple, it's just showing you the expected unserved energy. And all expected unserved energy is it's just saying that when you do have an outage, how many megawatt hours of energy basically are you short? So it gives you an idea of the depth or the magnitude of the outage when you actually have one. So the higher the number, the worse off you are when you do actually have an outage. Okay, so the first set of numbers there, the first set of bars that we see speaks to back in 2019 when we had the 12% planning reserve margin when we did these studies. It's telling you what loss of load expectation we had. So for instance, in the 2021 year, the tallest bar, our loss of load expectation was a 0.85. So less than the 1 day in 10 years. And the expected unserved energy associated with the event, and that's actually an annualized number, is about 130 megawatt hours. And so we're really using this to say this is where we were in the past before some of these changes that I talked about earlier in the presentation, like the retirements and such took place. What level of risk were we living with? And so then we want to compare that level of risk to the level of risk we see in the future, given the changes in circumstances. And we're looking at different planning reserve margin levels to help bring that home. So under a 13% planning reserve margin in 2023, we see that in our best case scenario, we do have a loss of load expectation that's less than 1. But in another reasonable case that we evaluated in the assessment, it showed more than twice the standard, going up to a 2 days and 10-year loss and a 504 megawatt hour amount of expected unserved energy. And just to put that in the context, 500 megawatt hours or so is about the amount of load shed or energy that went unserved during our winter event in 2021. So that's kind of the magnitude of type of event. At 14%, the numbers do start to come down some. You see in the worst case scenario, you have a 1.2.
Sorry to interrupt. I have a question. What was that about 500 megawatts in this example? Could you just repeat that statement? I want to make sure
megawatt hours?
Megawatt hours, yeah. What was that you were saying about it?
It just represents, if you wanted to try and understand what a 504 megawatt hours equates to.
Oh, I see where it is.
The load loss or energy unserved that we experienced during Winter Storm Uri in February of last year, it was on that order of about 500 megawatt hours. So just as a feel for the magnitude of what type of outage that would be, to better quantify the impact or risk associated with that. And that's an annualized number. So that would be per year over the 10-year period. You average that out to say that's the level of risk associated with an event that you'd be looking at. That comes down at 14% planning reserve margin in 2023. But the only case that brings both the loss of load expectation and the expected unserved energy below those thresholds or in an area that is that resembles the risk we live with today is 15%. And that was the primary driver for the selection of the 15% and why we felt like it was urgent to have the planning reserve margin increase effective next summer rather than a stair-step approach, which would yield what we at least deemed to be pretty significant risk in the meantime as we were working to get to the 15%.
Madam Chair?
Yes, Commissioner Fishman.
Yeah, Mr. Lucas, a question. When you're calculating the planning reserve margin, is that based solely on generation or are generation and storage, or are demand response programs or demand limiting programs incorporated into that calculation as well?
Yes, so those demand response programs are included in the calculation as more of an offset to load or offset to demand there.
Okay.
So yes, so the more access we have to those, the better impact it has, I guess, in lowering what our planning reserve margin requirement would be.
Okay, and is that is there much of that going on at this point, or is it just kind of getting off the ground?
It's fairly low now. We have about just under 900 megawatts of it across the whole system today. However, we expect that to increase significantly looking forward. Now, I will say though, based upon that, we did do some analysis that suggested that there's risk associated with that as well. If you're able to access those programs, it's great. If there are any limitations in accessing those programs, we see a very direct impact that it has on the planning reserve margin that you need. And that's something that we're going to be looking at going forward on how we can ensure that there's a very strong link to the access to those programs to make sure that they perform as projected.
Thank you.
Commissioner Fishman, I just would like to jump in there for a minute. What was going through my mind was, I guess, a related idea in that I was wondering what effect AMI, the use of AMI by utilities that are members would have. And of course, that's a tool to empower, demand, higher use of demand response type programs. And I don't know I guess what I'm wondering about is the RTO just simply runs the market, but in terms of their rules, can they establish rules that would, in the face of this kind of prediction you have for 2023, can they implement a rule that would require the participating utilities to implement some programs that would, reduce the level of risk here?
So as the RTO, we would not. We don't get involved in trying to determine or influence the decisions that are made on the generation side of the house. That's something typically our utilities work directly with their commissions on. We just try to make sure that everyone knows how those resources will be accredited from for the purposes of resource adequacy, so that they can make the most informed decisions as they're working with their commissions.
Thank you. It's a good explanation. I appreciate it.
Okay.
Yeah. So please go ahead.
Okay, next slide, please.
Mm-hmm.
Okay, so benefits and value of the increased PRM, as we see it increasing the planning reserve margin requirement for 2023. We do think it's an incentive for companies to keep their capacity in SPP. That was one of the big concerns that we had, is by lowering that requirement system-wide, those entities that actually do have excess generation would really have no incentive to maintain it or keep it within SPP. And we definitely didn't want to lose generation, knowing how tight we expect things to be going forward. We think it creates an incentive for companies to go out and get the additional capacity that's needed. And it's really because it increased reliability and reduces operational risk. And it also reduces costs associated with extreme events. And, I don't like to harp on that too often, because we know those things are really costly when they happen. And it's not a popular message when you're talking about the cost of some of these decisions, but it is a reality. We've seen the impacts when there are events. And then lastly, it does improve the public's perception about what we all are doing and working together to ensure reliability in the future. And I think that was one of the things that became pretty clear, that out in the community, the public is not always aware of a lot of the things that the types of decisions that we're all faced with and how we address those. And we think this also sends a proper signal based on what we're seeing from a managing reliability aspect as well. Next slide, please.
Madam Chair.
Yes. Mr. Fishman, and then I have a question too, but you can go first.
So in regards to extreme events, Uri, the prices went through the roof across the board. Fuel prices in particular. But I assume that happened within the SPP markets as well. Is that correct?
Yes.
Okay. So are there any specific market rules that can be put in place that moderate those price spikes during extreme events? And is that any part of what SPP tries to do?
So I think there are some that already exist in our market today, some cost caps that are there. I think, I'd say a lot of the price increases that we saw were associated with gas and gas availability. And, I know it's something the IRATF has been looking at and been talking about. I know we have limited control over, that industry and availability of that resource that we rely upon. But I do know we are looking at some market mechanisms that will put us in a better position in the event we had another scenario like this. I can't think of any pertinent details right now. I think that would apply specific to the cost of gas market prices.
Okay. Has there been any effort by RTOs in general to lobby the federal government? Because I think that's what it takes regarding gas prices, some kind of federal regulation that puts some guardrails in place in emergency events to at least dampen some of the price spikes in those commodities.
Yeah. Well, so we haven't done that, but I can tell you what we have done is we've been working a lot around the definition of what constitutes a force majeure for the purposes of generation availability and delivery that allows those supplies for contracts and such to, I guess, be abandoned. And so we're working on that definition so that, to see if there's a way that it becomes a little bit more difficult to declare those in these types of situations or scenarios.
Yeah.
And then we're really working to coordinate with the gas industry as much as possible. I know we've had a number of meetings with folks in the gas industry, just trying to better coordinate our processes and determine how their industry works and sharing how our industry works to figure out opportunities that we can close and bridge the gap as well. So we're approaching it from a number of different angles.
Yeah, one final question on this. I was surprised to see that during Uri that a lot of our utilities, in terms of their gas supply contracts, only 60% of them were locked in, 50 to 60%. And the other 40%, they were just exposed to the day-to-day market. And I'm curious as to whether you guys have done any work on that area or examined what kind of the normal industry practices are there to see if they still make sense.
Yeah. So I do know that part of the IRATF's work, there has been discussions and considerations around requirements for firm gas, which would, I think, increase that ratio, I think that you mentioned there. But we try to separate some of this stuff from Uri as much as possible because that was such an extreme event. And I think even with firm gas, I think we still would have had a gap. But that doesn't mean that there wouldn't be other cases less extreme than that where a requirement like that might help. But I don't want to jump the gun before that group has completed its work on those recommendations. But I do want you to know that is something that's been discussed within that group.
So what struck me, and I lied, I do have one more comment here, is that Uri, essentially the fuel costs for folks for that 1 week event, that added a year of additional fuel costs to your typical utility customer, at least in our jurisdiction. Mm-hmm. And that extreme event had extreme consequences. And I guess my comment would be, we should be careful not to underestimate how expensive the extreme events are. And the way we put together. So if we're saving 5% a year by doing a particular project, well, we had 10 years prior a similar kind of event to Uri, at least in New Mexico. We had a freeze. I think it affected Texas some too. We should take that into consideration. 5% annual savings may not justify taking a little more risky approach. Maybe we need to pay more attention to those extreme events. Yeah. So I'll just throw that out there as a thought.
Thank you, Steve. And I appreciate those questions, actually. And I hope the task force is looking at extreme events, because we've had at least 3 in the past 20 years, and they might be just 3 dots, but that makes a line. And the last 2 were a little bit more frequent together, closer in time than the previous one. So my sense is we're going to see more of that with more climate change. But my question had to do with your first point up here about how the benefits and values of increasing the planning reserve margin will incent companies to keep their capacity in SPP. And I just want to ask about that. I mean, I know that because I believe you have to have geographic, you have to be geographically attached to, have a border to be able to benefit from being in an RTO. So I can, looking at the map, I can see how, there are a number of entities along that border that could maybe want to switch, but there's also a big disincentive to leave in the exit fee they have to pay. And I guess I was just wondering how potent an incentive it really is, given the fact that, we're a company to, say, defect from SPP. I mean, the most logical place for them to go would be MISO, and are things really, is grass really that much greener on the other side of the seam, Okay. So do you really think they'd want to leave if there was a...
So that, I'm glad you asked that question, because I did not intend to suggest this meant the utilities themselves leaving SPP. It's just that some of our load responsible entities are long on excess generation, while some are short. And the ones that are long, they have an option to sell their excess capacity. And everyone around us is struggling with the same capacity issues. And so we wouldn't want our entities who are long excess generation to engage in contracts to sell that generation to other parties outside of SPP, and then those resources not be available to SPP in the event we had system constrained conditions and we needed that capacity. So it really is just about the excess generation that we see. As a whole, we see enough generation in SPP with the, with the generation that we have in the planning reserve margin. It's just that the planning reserve margin is assessed to individual LREs. And some of our LREs are short and some of our LREs are very long. So the generating capacity for the system is there. It's just not within the fleets of certain load responsible entities. And we would like for those, or our construct in our resource adequacy process is for those parties to contract together to, swap excess generation. But if that generation gets sold off system because there's no contracting that takes place, because let's say we went with a 13% planning reserve margin requirement rather than a 15, well, now we get into real time and we need it. That generation, has been sold and belongs to someone else and we don't have access to it. So that was the point we intended there with that bullet. Sorry for the confusion.
I see. Yeah. And you say specifically to keep their capacity in SPP, but I understand now. I guess it's designed to put a little pressure on those companies that are sort of short in capacity. So they'll be searching around within the RTO to purchase, I guess, rather than.
Yeah, I guess to say it even more clearly, if an entity that, let's say when our requirement was 12%, we had an entity that had 15%. If we did the stair step approach and only changed the requirement to 13% for next summer, the entities that already have 15% could say, oh, I only need 13, so I can sell the incremental 2 points off system. By setting the requirement at 15%, those who have 15% will maintain it or be obligated to maintain it. And then that generation would be available to the system to help meet SPP's overall reliability needs.
Oh, I see. So, all right.
So we were trying not to lower the requirement to the lowest denominator and create the potential to lose capacity that we already had available.
I understand now. Yeah. Well, thank you.
So Commissioner
I'll
Hall,
reword this bullet in the future.
so Madam Chair,
yes,
it just kicked off one more question from me. So we've got
please go. Please ask.
SPS, the entity that serves us from the SPP. They have lots of excess capacity for various reasons, but do they have the freedom then? Basically, they're obligated to give 15%, make 15% available to SPP, but they still have the option to sell excess over that to a different RTO or different entities than through the SPP markets? Is that how it works?
Yes, any generation that's above the requirement is excess that could be used however, I guess they please.
Okay, thank you.
Thank you. You can proceed, Mr. Lucas.
I think I may have just one, maybe two slides.
Okay.
Let's go to the next slide, please. Okay, and these are some of the options which we've talked through some of them on how to meet that requirement for some folks. They could improve their resource accreditation, and that's, primarily, through maintenance and other activities that improves performance. They could purchase existing excess capacity from others, defer currently planned retirements, reduce off-system sales. As Commissioner Fishman mentioned, they could increase demand response and or interruptible load, and then also use interim service in the generator interconnection process, which is just a mechanism that allows generators to interconnect to the system prior to completing the full generator interconnection process. And so the last slide, I think, just shows the recommendation that went to the RSC and the board. If we could pull that up, just so you see the specifics there and see that this was also unanimously approved by the regional state committee and then also passed at the SPP board of directors. And I apologize. I do have I guess I can't call it a hard stop at 2 o'clock because it's after 2 o'clock, but
yeah,
I will need to run. But if there are any questions, just let me know. You can reach out to me at any time. I hope my contact information is in the slide deck. But if not, we can make sure you have that and I can answer or at least get you an answer for any questions that you all may have.
Thank
Does
you.
anybody
Very
have any
informative.
further questions?
Just wanted to say thanks. Great presentation.
Okay, great.
Thank you.
Any other commissioners have any comments or questions you want to make? I don't hear anything. Oh, yes, Commissioner Byrd.
If you guys need contact information, let me know and
Okay.
because I don't see it on the slides, Mr. Lucas, but we'll get it.
Okay.
Okay.
Thank you.
Thank you.
Okay, excellent. And I have no other questions either, Mr. Lucas. So I want to say a very big thank you. This has been a very clear explanation of why they have to go from 12 to 15% for their planning reserve margin. It's been an excellent discussion, and I really appreciate you taking the time to come and explain this to us and answering our questions so well.
Oh, well, thank you all for the invitation, and I appreciate you all having me.
Okay, great. Well, thank you. Have a good rest of your day. And let's see, commissioners, does anybody have any other comments to make about that presentation? If not, we'll move to our item number 15.
Madam Chair, just real quick.
Sure, Commissioner Burton.
So in the process leading up to the vote was quite a few months of discussions with Mr. Lucas, as well as, and I'm drawing a blank, dang COVID fog, it may come to me. But anyway, there was quite a few people involved with getting the correct information, the amount of information necessary. We went through quite a few education sessions talking about it, asking questions. It was not known at the day of the vote if it was going to pass or not. In fact, my vote was still pending until later in the day. So anyway, and I'm not the only commissioner. I know at least Oklahoma and Texas were on the same side as I was, but we ended up, as you see, voting unanimous. Our SPP staff did a great job, as PRC staff does, in really digging into the information, getting answers to all the questions. And so you got a 1 hour version. We spent days talking about this, as you can imagine, just like when we are dealing with an issue before us that we have to vote on that is contentious, because as I mentioned, the majority of the utilities themselves were not in favor. And it wasn't, what their concern is that utilities look long-term. They don't plan for tomorrow, they plan for the next decade. So their concern was making it jump this high, this quick next year, right? Just a few months. They're looking at, all right, so we have to start looking at where we're going to build more generation. And one of the reasons, and I'm just reasoning through, just so you guys understand, one of the things that changed my vote to yes was that if you saw that chart in 5 years, we would be, SPP footprint would be under capacity would be less than the reserve margin in 5 years. It takes a utility a minimum of 5 years to build new generation. So by doing this vote now, it forces them to get busy, and it gives them the incentive necessary to go to their respective commissions and say, we need new generation. And as you guys know, this takes forever to get stuff built, get a site's approval and everything like that. So that was why I voted in favor, is because we had to get that ball rolling. I know the utilities weren't happy as members. They wanted to phase it in over a number of years, stair step it up. So anyway, I just want to kind of give some perspective, try to relate it back to what we deal with as commissioners, and the RSC was very thoughtful in their questions and the process. And I want to thank SPP for all the work their staff did. That's it. Thank you, Madam Chair.
Commissioner Byrd, I've got a question for you. I was wondering what the vote of the members was too, and what, because he didn't, apparently wasn't unanimous like it was at the RSC. And so I appreciate you letting me know where the company stood on that. And from what I believe of the makeup of the states and the utilities, there aren't that many members who have the kind of aggressive renewable demands that we have in our state. So I guess they're looking at the challenges of building more fossil development, which can be done within a 5-year time frame, but it's not as easy as renewable build out. Can you, oh, I had a question there. Can you speak to that? Or is it their operational concerns, or is it the rate impacts that they were being concerned about, or both?
So one of the biggest drivers is that alternative energy is becoming a larger portion of the supply, but it's less consistent and less reliable. As we remember, the first few days of that storm, Sunday specifically, alternative energy didn't perform anywhere close to what we expected anywhere. It was actually near zero, which is really unusual. The wind just wasn't blowing, or that it was covered in ice. And
actually in Kansas, it performed very well.
It did later in the system.
Yeah.
It did later in that storm, but on that one day, and that, if you remember, that Sunday is also when the gas prices spiked and went crazy, and what is that? It wasn't just a perfect storm for being really cold. It was a perfect storm for our utilities. Everything that could have fallen apart fell apart on Sunday. Right? Gas quit being delivered. Prices started to go up. Wind quit blowing. It was cloudy, so the sun was minimal. They had already spent the batteries back on Friday, so the batteries weren't there. They couldn't be recharged because we were down low. We were so low in meeting demand that they didn't have any extra capacity to recharge. It was just that perfect storm, right? In every respect. So they're looking at that, but what they have also decided, and this is why they're changing the accreditation, is that some coal plants, gas plants are 400 megawatts, but they never give them 400 megawatts. They maybe do 390, 385. And so on paper, they're saying, well, we can get 400 here, 500 here. And in reality, they never were. So they're reconsidering the accreditation process. That's why this is all being piled in together. So it's real-time accreditation instead of nameplate accreditation on firm power. And that's wise, because they just never, especially an older unit, right? They lose efficiency as they get older, and they don't make what they were designed to make anymore. So anyway, I think that answers your question. If not, I'm still here.
Thanks a lot. Yeah, that helps. And I guess I was wondering about the price cap issue that Commissioner Fishman brought up. I believe SPP and MISO, most RTOs have a price cap of some sort. Was there any debate among the members about the price cap? And when I say members, I don't mean just utility members. I mean all the other members, because I just wondered. I mean, there is a government component there, an environmental group component, alternative fuels, I think they call it. Was there some debate about what would be a reasonable price cap, or was that just an issue that's not one of their central issues?
Also, there's a price cap on the price of electricity, but remember, there's always that fuel surcharge that generators pass through the fuel charge. So when their fuel charge skyrockets, they still pass it through, which is what we saw. So the prices spiked
fuel
They
charge.
couldn't charge more for the electricity, but they still get to cover their cost for the fuel.
Yes.
Yeah.
So, so what were they talking about at the RSC about that? So actually, I remember there's a price cap, but I don't recall whether there's any kind of a cap on fuel charges. Are you saying there was, or they were
No,
considering it?
because you would lose in court every time.
Yeah.
They have to be able to recoup their costs.
Yes, they do. Yep. Okay. All right. Anybody else have any other questions? We are adjourned.
See you guys.
Thank you.
Madam Chair, this is Miguel Fishman. We got those comparison charts posted up.
Okay.
Oh,
Thanks for
terrific.
that
Thank you,
information.
Miguel. Where do we find them?
Under utility, and then I had Phil, he made a IOU comparison.
In the trash bin.
Oh.
Up on our main
IOU
website.
comparison. Where is that? Same place, utilities?
Yeah.
Okay.
IOU comparison.
Thank you.
All right.
Bye, everybody.
Thanks for bringing that forward.